Ready? Oh, yep. Thank you for telling me. All right, let's roll, nerds.
Just bottom of page 4, Falcon. Come on.
Hi, good morning.
Sorry. Yes.
Mr. Falcon, you're charged with failure to identify oneself as a fugitive from justice. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On February 10th, 2026, officer in Harris County, Texas, observed defendant's motor vehicle traveling above the school zone limit of 20 miles per hour. Defendant was traveling 45 miles per hour in a 20-mile-per-hour zone with defective brake lamps. A traffic stop was conducted. Defendant advised he did not have his Texas driver's license on him, but gave officer a name and date of birth, was returned for a warrant out for his arrest. Officer placed defendant into custody where he stated, I may have given you the wrong name. I was just scared, and provided his real name and date of birth.
So what name did he give initially?
He gave the name Oscar Rock.
Got it. Okay. What does he have open? Do you know?
So, running his history. right
Did he,
now.
does he have anything else that's open?
So I currently show no open warrants. I'm running his NCIC right now.
Okay. Perhaps it was traffic. Mr. Falcon, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to drive unless you have a valid Texas driver license and liability insurance in your name. You must maintain liability insurance. If you don't have it, then likewise, no driving. Do you understand? I don't care what you have to do in this life. If you don't have a license, do not drive. I'm not going to warn you again.
Your Honor, I don't see an open case aside from.
No. And then does he have a license to drive? Do you see?
I'm running his license.
Please. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with counsel, and she'll tell you if and when you have to come back to court. If she tells you she cannot get a hold of you, then likewise, you will go to jail. Looks like you had a case in Brazoria County. Is that still open or?
It is not, Judge. It was a,
It doesn't matter. I mean,
it's
just
taken care of now.
got it. Did you represent him on that?
I believe we did.
Yeah, okay.
Well, not the original case, but yes.
The stuff.
His license is not eligible, Your Honor.
Hey, you're not allowed to drive. You're going to be signing an affidavit with me today promising you're not going to drive. Like I said, I don't care that you have to go to work. I don't care that a kid has to go to the hospital. I don't care that you need food. If you drive, I'm going to put you in jail and no more PR bonds. Do you understand me? All right. We're going to have you come sign this, and after that, we'll get you out of here. We need you to sign more bond conditions, and after that, you'll get out of here. All right. Come on.
All right, Judge, next is top of 16. Chauncey Barrows, Ponce.
What page, Victoria?
Top of 16.
16. Okay, then. Oh, and I have Herman here online as well. So Herman, I'll hit you up next. Good morning, Mr. Ontiveros. You speak English? Sir, good morning,
Yes,
sir.
sorry.
You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Good morning, Mr.
On March 5th, 2026, in Harris County, Texas, officer observed a vehicle failed to stop at a designated stopping point at the intersection of 13th Street and East Boulevard by passing over the marked stop line before stopping at a red light. The vehicle also conducted a wide right turn and failed to maintain a single lane. A traffic stop was conducted. The driver and sole occupant was identified as defendant. Officer observed red bloodshot eyes, droopy eyelids, thick slurred speech, and a strong odor of alcoholic beverage emitting from defendant. Defendant stated he left a sports bar and that he consumed 4 Modelo beers. Standard field sobriety tests were conducted, 6 out of 6 HGN, 6 out of 8 walking turn, and 2 out of 4 one leg stand. The IC was read and defendant refused to provide a sample. A blood warrant was executed and a blood was drawn.
The stop was for what?
He failed to stop at a designated stop.
Okay, so stop sign. All right, got it. All right, Miss,
It was a red light.
oh, it was a red light.
He stopped over the line.
Oh, the white line?
Yes, and then made
Got it.
a wide right. turn.
Okay. I just look at it and tell me if you see something different.
I will.
Come back and let me know.
Yeah, they
I'm
state that he
just get it.
stopped,
and
but- Okay.
Let me know.
Yeah.
You know, I mean, any priority to license, does he have a license?
No priors, Your Honor, his license is optional.
Okay. For now, Mr. Ontiveros, I'm going to find that there's sufficient probable cause to go forward with your case as a condition of your bond. You're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds. Do you understand, sir?
He has a cash bond, Judge. He wasn't on a PR bond.
Doesn't matter.
Okay.
Yeah, just
Yeah.
don't drink, don't use illegal drugs, don't drive unless you have a license and insurance. I'm not asking for much. Do you understand? Because you have a lawyer, I will waive your appearance, so you don't have to waste your time coming to court. Just stay in touch with them. They'll tell you if and when you have to come back to court. For now, we'll have you just sign a reset. You'll get with, reach out for your bond conditions and free to go.
Thank you, Judge.
Come on.
Thank you.
Got it.
Good excuse.
Yes, sir.
Have a great day.
You do.
Judge Herman has page 22 and 23. Ventura.
Good morning, Your Honor.
Herman, say something.
Yes,
make sure-
sir. I'm here.
Deputy, do you mind hitting on the sound bar? There's a button on the other side, just right in the middle. Just if you want to hit it one time, please.
Yes, sir.
Herman,
Yes, sir.
no, one more time. Just hit it one time. Say something.
Yes, sir. I'm here.
There we go.
Yes, sir.
Okay, thank you so much. All right, you are Mr. Ventura. Sir, you're charged with 2 cases. You're charged with driving while intoxicated and unlawful carrying of a weapon. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine, and on the gun case, up to a year. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. As you see, you are not here alone. If you look on the TV, your lawyer's here with you. Okay.
On March 8th, 2026, in Harris County, Texas, officer was dispatched to a traffic hazard call at 9900 Center Parkway. Officer stated that defendant was a sole occupant of the vehicle and asleep behind the wheel. The vehicle was in a moving lane of traffic. An officer observed defendant to have bloodshot eyes, slurred speech, and vomit on his shirt. Defendant admitted, defendant was coming from his cousin's house and stated he was driving home. During the field sobriety test were conducted, 6 out of 6 HGN, 2 out of 8 walking turn, and 2 out of 4 one leg stand. DIC was read and defendant provided a breath sample. Results were 0.149 and 0.142. Officer recovered a firearm from the glove compartment of the vehicle and 2 magazines in the center console.
Would you say the stop was? I zoned out.
So the officer was dispatched to a traffic hazard call and the defendant was stopped in a moving lane of traffic.
Got it. Okay.
Your Honor, I
Sure.
didn't hear anything that indicated that when Mr. Ventura was operating a vehicle, he was intoxicated. The engine was off and they don't do anything to pinpoint when he was operating the vehicle. There's
Well,
no witnesses of
In a
him
moving lane
operating
of traffic,
with the
it
engine off.
stops and he's alone.
He stated that he, to your honor,
Oh. Did you hear that, Herman?
I did not.
he stated he was coming from his cousin's house and driving home.
Okay, but it still doesn't pinpoint the time. He could have been sitting there for an hour and they don't know what time he was operating. There's no evidence of him operating at a time where he's intoxicated.
Okay. Well, I mean, I think that there's enough to go forward, Herman.
Fair.
Sorry.
Fair.
Mr. Ventura, I'm going to find that there's probable cause to go forward with your case, and I am now ordering you, and I'm placing now a restriction on your license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. Do you understand? No,
Judge,
no.
may I address that? I thought he was under 1.5 without an accident.
He has a prior DWI from 2.5 years ago. He's got vomit
Sure.
all over himself.
Okay.
You know, he's passed out. You're going to get an interlock if you don't drive
Okay.
without one. I only have one place for you. Do you understand me? I'm not here to play the games. I'm here to protect my community. I'll do it at all costs. And if I have to throw your ass in there for a long time, you and only you hold the keys to the cell. I'm not asking much. I just don't want you to consume alcohol, no illegal drugs, and don't drive without an interlock. Do you understand? I'm not asking you to reinvent the wheel. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Herman, and he'll tell you if and when you have to come back to court. If he tells me he cannot get hold of you because you're ducking and dodging, likewise, a warrant issues. This is not a revolving door. If I have to put you in jail, I'm going to revoke it and I will make it high. Do you understand? Does he have a license to drive?
He does, Your Honor. I would let Farwell confirm that it's eligible, but we've done the ALR.
Okay.
Yes, Your Honor, I'm running the license number right now.
Okay. One more thing. If you are to drive, you must maintain liability insurance in your name. That is also a condition of your bond. If you don't have car insurance, then no driving until you do. Do you understand? All right. We'll have you sign a reset. You'll get pre-chop for your bond conditions. After that, you'll be free to go.
All right, judges, page 12 through the 14.
Did you hear that, Herman?
I'm sorry. No, I didn't know that was going to be my, what is it?
May 12th through the 14th.
I'll take the 13th, Your Honor.
Okay. And then can you file the interlock paperwork?
there,
It's in there. Okay, great.
Thank you, Your Honor. Have a good
Okay,
weekend.
thanks,
everyone.
Herman. Have fun.
This license is eligible, Your Honor.
Great.
All right, Judge, top of page 1, Aosta.
Mr. Acosta, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 5th, 2026, officers received information of a parking lot takeover. Officers observed a motor vehicle perform 3 donut burnouts within 15 feet of several motor vehicles and bystanders. A traffic stop was conducted and defendant was identified and admitted to doing the donuts.
Do they have a license to drive?
But we do not have a license.
Mr. Acosta, I'm going to have you sign an affidavit with me today promising me you're not going to drive. If I find that you do, I can have a contempt hearing, and every time you drive, you can be facing 180 days in jail and a $500 fine. I don't know why you're smirking and laughing. This is your second reckless driving within a year. If I find that you endanger my community, I'm going to lock you up and I'm going to make your bond high. You were ordered not to consume alcohol or illegal drugs, and I'm going to test you like crazy to make sure you're not using. Test next week, please. You will be tested for drugs and alcohol, illegal drugs and alcohol. If I find out you're using, likewise, you will go to jail. No more PR bonds for you. You will be signing this affidavit promising me that you're not going to drive. I don't care what you have to do in this life. Do you understand, Mr. Acosta? Come up here. We'll have you sign it. I'm going to reset your case to give you time to hire a lawyer, and then we'll have you meet with pre-trial.
All right, Judge, bottom of 2, Bishop.
Did they confiscate the car?
I can check it with Your Honor.
No. Ma'am, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 8th, 2026, officer checked by on a crash in Harris County, Texas in regards to DWI investigation. Officer advised that upon arrival, defendant was standing outside her vehicle, keys on her hip. Defendant stated the crash was her fault. She lost control of the vehicle and struck another vehicle and hit the walls on the side of the freeway. Officers observed a strong odor of alcoholic beverage and red glossy eyes, and defendant advised she consumed 4 shots of tequila. Standard field sobriety tests were conducted, 6 out of 6 HGN, 1 out of 8 walking turn, and 3 out of 4 one-leg stand. DIC was read and defendant provided a breath sample. Results were 0.142 and 0.144.
Any prior DWIs,
No prior DWIs, Your Honor.
license?
Eligible.
Ms. Bishop, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, you will go to jail. I will revoke your bond. You understand? Yes or no?
Yes, sir.
You are not allowed to drive unless you have a valid license, and you must maintain liability insurance. If you don't, then likewise, no driving. You have the ability to hire a lawyer.
Yes, sir.
Okay, we'll give you time. I'll have you go to Victoria Center, reset. You'll go pre-op your bond conditions, and after that, you'll be free to go. There's a lot of timing requirements with the DWI. Don't wait a month. Don't wait 2 months. You need to get on it quick. All right? Okay, please.
All right, judge, council's approaching for top of 17. Reyes, come on up.
Yeah, the outside of Marcus Spears, I don't know if you want to do both.
Sure,
Okay.
let's do
What's
it.
the other one?
Spears. Marcus.
So the first one was top of page 14,
Top of 17.
17. Got it. Ah, okay. And then the other one was which one?
Spears.
Spears. Just last name, please,
Page
Runs.
20. or yours.
Good morning. Each of you are charged with driving while intoxicated. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Ms. Reyes, yours is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. Sir, you're facing up to 6 months in jail and or a $2,000 fine.
For Ms. Reyes, Your Honor, on or about March 7, 2026 in Harris County, Texas, officer assisted other officers on a major crash on Gulf Freeway. Defendant was driving one of the vehicles. Witness observed defendant driving the vehicle on Gulf Freeway on the shoulder at a high rate of speed, almost striking his vehicle. Witness observed defendant lose control of the vehicle and crash into another vehicle. Witness stated that the defendant said she was trying to have fun and didn't mean to hurt anybody. Witness 2.
So what, like a demolition derby?
Yes, Your Honor. Witness 2, the driver of the vehicle that was struck, stated she was all of a sudden struck by defendant's vehicle. Defendant was detained for being non-compliant during a crash investigation and stated she was coming from a friend's house where she was playing drinking games and that she consumed 3 to 4 margaritas in total. She also stated she took Adderall medication that day at 12 p.m. Officer observed defendant to have high emotion, red glossy eyes, the odor of alcoholic beverage, poor balance, and slurred speech. Standard field sobriety tests were conducted, 6 out of 6 HGN, 7 out of 8 walk and turn, and 4 out of 4 one-leg stand. DIC was read and defendant provided a breath sample. Results were 0.167 and 163.
Okay. Any prior DWIs?
No prior, Your Honor.
Any prior contact with the law whatsoever?
I got no criminal history.
No. Okay. If you want to go ahead and the gentleman.
On March 7, 2026 in Harris County, Texas, officer was dispatched to a traffic hazard on FM 1960 Road. Officer observed defendant sitting in the driver's seat and defendant to have strong odor of alcoholic beverage on his breath, red bloodshot eyes, and slow slurred speech. Defendant stated he was coming from a bar in Perome and that he had two drinks. Standard field sobriety tests were conducted, 6 out of 6 HGN, 5 out of 8 walk and turn, 4 out of 4 one-leg stand. PIP was read and defendant provided a breath sample. Results were 0.142 and 144.
Did you tell me if Ms. Reyes has a license or no?
She does, Your Honor, and it's eligible.
And on Mr. Spears
Mr. Spears is
and any prior DWIs?
his license is eligible and no
Great.
prior to elected.
Okay.
And Ms. Reyes does not have a vehicle at this time.
I'm ordering her to obtain a portable device.
Yes, sir.
Ms. Reyes, I'm going to find that on each of you, I'm going to find that there's probable cause to go forward with your case. Both of you are ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using anything that's illegal, you will go to jail. That includes controlled substances, marijuana, anything. If you use, you go to jail. And I don't care what your excuse is. You, ma'am, I am now ordering you to obtain a portable device, and I'm ordering you not to drive any vehicle that doesn't have an interlock on it. I don't care what's going on in your life. I don't care what you need to do. I don't care where you got to go. I don't care if you need groceries. If you don't have an interlock on a car, you are not allowed to drive. Do you understand? I'm sending notice to DPS so that every police officer in the state knows if they pull you over, the car that you're driving doesn't have an interlock, they will take you to jail. You will get a portable device now, so proving to us that you're not going to consume alcohol. Do you understand? Because both of you have lawyers that will waive your appearance, it is your responsibility to stay in touch with them, and he'll tell you if and when you have to come back to court. If he tells me that he cannot get a hold of you because you guys are playing games, if you pick up a new charge, if you are a danger to my community, I'm going to revoke your bond and I will put you in jail. No more PR bonds. Do you, each of you understand? All right, you'll get to Victoria, sign a reset. You'll get with pre-chop for your bond conditions, and after that, you're free to go.
Thank you, Your Honor. Maybe-
Please. Yes, sir.
All right, Judge, top of 3, Bowens. And I have these for you.
Well,
He's waiting for my. Maybe we'll see. Go ahead and have a seat when you bring up.
Last name, sir?
Top of 3.
Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officer spoke with complainant and stated that on September 14th, 2025, at 3050 on Lita Genoa Road in Harris County, Texas, her ex-boyfriend defendant assaulted her. Complainant stated that she and defendant dated for a year, and that on September 14th, she was driving westbound on Almeida Genoa from Coburn, and that defendant threw a drink in her face and was pulling her hair while she was driving. Complainant had to pull over into a dollar store nearby due to her not being able to drive while her hair was being pulled. Complainant stated they both got out of the vehicle, and she told defendant to stop. Both parties then got back into the vehicle and continued. Complainant stated she got on the 288 when defendant started to pull her hair and punch her in the face with a closed fist. Complainant stated she bit defendant's finger while trying to defend herself and pulled over again. Complainant stated they both got out of the vehicle. Defendant was in her face, calling her a bitch. Defendant then headbutted the complainant to the forehead. Complainant pushed defendant and got into the vehicle to leave. Complainant made it home before calling the police. While speaking to the police, complainant noted that defendant was nearby because watching him. Sorry, Your Honor. Defendant was nearby watching due to him calling and stating, "Why did you call the police?" Complainant went to the station the next morning to file a report and stated that defendant pulled her hair and punched her in the face with a closed fist, causing her pain. Complainant provided pictures of false spots caused by defendant pulling her hair and a busted inner bottom lip. Complainant stated that on September 20th, she had another incident located near Cullinan Airport in southeast Harris County, Texas. The complainant stated defendant ran up to her and pinned her near her vehicle and stated she took his ring the day of the last assault.
So after the assault occurred, there's another contact?
Yes, Your Honor.
What day? Because he was under bond. So did he get arrested? Because he's under bond conditions. And if you're telling me that there's subsequent contact, I'm going to put him in jail.
The initial incident was on September 14th, and then the next incident was on September 12th. We can look at the response conditions, Your Honor. There was a. Your Honor, it looks like the MOAP and the bond conditions were not filed in the 20th.
Mr. Bowens, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, you will go to jail. I'm ordering you to stay at least 2,000 feet away from this person. If you go anywhere near this person, I will revoke your bond and put you in jail. I'm going to put a monitor on your ankle so I know where you are at all times. And if you go anywhere near this person, you put hands on this person, anything, you will go to jail. I will deem you a public danger, and I'm going to make your bond extremely high. Do you understand? I'm going to protect my community at all costs. And there's nothing you can say at this point, but let me enlighten you on something. If I have to put you in there and make your bond $500,000, I will do it, and I won't lose a minute of sleep over it. You understand me? I don't care what is going on. I don't care what you need. I don't care if she's got Bambi in the house and you need it. You try to have any kind of contact, I'm going to lose it. Do you understand me? There is a protective order that has been issued in this case, and you need to get to know it. If you do something to violate this protective order, the state can and probably will file a violation of a protective order, and that is the capital murder of misdemeanors. Do you understand? No contact means no contact at all. I don't care who initiates it. I don't care if she calls you. I don't care if if she texts you, comes to your house, no contact means no contact at all. She calls you, hang up the phone. She texts you, do not reply. She comes to your house, do not answer the door. You are the one that will go to jail. Do you understand? We are going to reset your case to give you time to hire a lawyer. I will have you go to Victoria Center, reset. You'll get reach out for your bond conditions, and then we'll have you take a seat while we get all the paperwork. And after that, you'll be free to go. Come on. Yeah, it was a 2B at the time. So, right. He wasn't under bond condition at the time. So, hey,
Just briefly on Spears and Reyes. Spears, I know he has no travel restrictions. He just wanted to let the court know he does have plans to go out of the country next week. I told him he needs to check in with pretrial.
how long is he going and where?
I think 5 days.
Okay.
Into where? The minute.
Okay, he's not allowed to use. He's going to get tested. When he gets back, let him know we have tests that go back a couple of weeks. So if we find out he's using, then he's going to go.
Okay,
Yeah.
sounds good, Judge. And then for Ms. Reyes, she says that she was going to try and get a rental car next week.
Whatever car she's driving, she needs an interlock on it.
If it is a rental car, there's no way we can get a.
Then she's not driving. I don't care.
Okay.
I want her that she's got to have an interlock.
Okay, understood,
Yeah.
Judge. Thanks.
Okay, all right.
Appreciate it.
Sorry, Runs. Hey, hey, sure. No, can we do, please? We've got a ton of stuff. And then I've got an Chinese, I've got the interpreter.
And council's not here yet.
Yeah, please just.
Council, Evans is.
Yeah, Evans is here.
12, Layman. Come on up.
Hey, Colin. So, Miss Woe, we're waiting on the defense counsel. As soon as they get here, I'll let you know, okay?
Morning, Judge.
Hi, Colin.
THA?
THA, yeah.
All right, go ahead.
Did you see who this is? Starts with an L. Layman.
Layman.
Good morning, sir. So, as you can see, your lawyer is here with you on Zoom. Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Pulling it up right now, Your Honor.
On March 6, 2026, officer in Harris County, Texas, observed a vehicle leave Little Woodrow's parking lot with no lights on. The vehicle did not have lights on when it made a left turn onto Washington Avenue and the traffic stop was conducted. Defendant admitted.
Wait. He left the parking lot at night without lights on?
Yes, I'm confirming the time, Your Honor. Yes, it was 1:30 a.m.
Okay.
A traffic stop was conducted on the vehicle and defendant admitting to having beers. Officer observed a strong odor of alcoholic beverage on defendant's breath and glossy eyes. Officers located empty beers under the motor vehicle.
There's beer in the vehicle?
Checking the DIM, Your Honor.
No, Judge. They're empty.
Yes, empty beers located behind the front passenger seat. Standard field sobriety tests were conducted, 6 out of 6 HGN, 1 out of 8 walking turn, and 0 out of 4 one leg stand. DIC was read and the breath sample was refused. A blood search warrant was executed.
Your Honor, if I may,
Sure.
glossy eyes are not a clue of intoxication. That was removed from the NHTSA SFST manual years ago. All they have at this point is my client leaving a bar parking lot. He had a brand new car that doesn't have the auto turn on for the lights. Apparently, that's a new thing that I've just learned. And he didn't manually turn it on. Although it was 6 out of 6 HGN that the officer claims.
But that's not a justification for not, if you're driving at night, you got to turn it on. You can't just rely on the car to turn it on for you.
Sure, and it was a new car, Judge. He wasn't used to it yet, and he was used to my car has the auto lights on, so I don't ever look down and mess with it. So, as far as the stop, the lights were off. The lights were off. I'm not arguing that there wasn't a reason for a stop, Judge, but I am arguing that there is no PC for an arrest for DWI. There are no other clues of intoxication. There was an odor of alcohol. He admitted to drinking, and that, as the court's well aware, that is not illegal.
He's coming from a bar. It's 1:30 at night. He's got beer in the car. He's got an odor of alcohol. He's got glossy eyes.
Glossy eyes are not a clue of intoxication, Your Honor.
Your Honor, we also admitted.
That was, and that is not illegal. Drinking at a bar at night is not illegal, and driving after doing so is not illegal. He had 1 clue in the walk and turn and 0 clues on the one leg stand, Judge. There are no other clues that the officer notes as far as unsteady balance, having to use the car to balance or check his balance, anything like that. Nothing as far as
But he fails the HGN though.
And Judge, I've had Officer Roy in cases recently, and I haven't had a chance to look at the video yet, but I'd be willing to put money down that it wasn't administered correctly.
But I can't, I can't, it's not fair to the state to, take.
It's also not fair to my client to be arrested for something that he didn't do. I mean, they didn't even reach the decision point. You've got to have 2 clues at a minimum on the walk and turn and the one leg stand to reach that decision point.
I believe there was enough to conduct a DWI investigation. Defendant admitted to drinking. He had a strong odor of alcohol.
I think that there's certainly enough to begin a DWI investigation. He's coming from a bar. It's 1:30 in the morning. He gets pulled over. He smells of alcohol. He's got beer in the car, regardless whether it may be empty or not, I don't know. But I certainly think that that's sufficient to initiate an investigation. Does the HGN, he fails. He does pass the other 2 tests, but this is just for probable cause purposes. I think there's enough for probable cause. There may be not enough for beyond a reasonable doubt, but I think that there's enough for probable cause. Mr. Layman.
I think that there's.
Go ahead.
Judge. I agree that there is enough for reasonable suspicion to conduct a DWI investigation, but at the conclusion of his DWI investigation, he did not have enough for probable cause, Judge.
He failed the field sobriety test. Granted,
that's assuming
it's
that the officer administered.
But okay, I'm going to find that there's enough for probable cause, Mr. Layman. The only thing I'm asking you to do at this time is do not consume alcohol or illegal drugs. If I find that you do, I will revoke your bond and put you in jail. You're not allowed to drive unless you have a valid Texas driver license. You must also maintain liability insurance. If I find that you're driving without either, likewise, you will go to jail. Do not pick up any new cases. A lot of this life is who you hang out with. If you hang out with the wrong people, they're not the ones that are on bond. You are. If they don't care. If they're doing something and you shouldn't be doing, and you hang out with them, temptation's a bitch. You know what I mean? So be very careful. You know, you ever have any issues, you got a great lawyer, talk to your lawyer, he can help you out, but there's just no excuse. You understand? All right. So for now, we'll just have you sign your bond conditions, and then after that, you're out of here. Let me have you go to Victoria, you'll sign a reset, you'll get with pre-chopper your bond conditions.
Go ahead and sign.
You said May 14th-ish, right?
I already picked the date.
Oh, you
Yes,
did?
Judge.
All right.
All right, Judge. Ready for the next one?
You know, get it, you know, call in if you want, get an expedited, you know, suppression hearing. I'm happy to do it.
Sure.
Okay?
Yeah, we'll consider that, Judge. And just to make sure, my client does live in Dallas, so if we can have this next appearance waived.
Yeah, of course. Yeah,
Thank you, Judge.
you got it. Okay, man. Thanks.
Take care. Have a good weekend.
You too, man. Take care.
Right, Judge, top of 4. Pelican.
Good morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Hey, deputy,
I'm sorry.
can you move those two right there in the gray sweater? They're just, they think it's the club, man. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 2026, in Harris County, Texas, officer observed defendant's motor vehicle strike at traffic control pole. Defendant, the driver, was detained. Officer observed a strong odor of alcoholic beverage, watery red bloodshot eyes, unsteady walking, and poor balance. Defendant admitted to drinking 5 beers at the Houston Rodeo. Student field sobriety tests were conducted, 6 out of 6 HGN, 2 out of 8 walk and turn, and 2 out of 4 one-leg stands. DIC was read, and defendant refused to provide a sample. A blood search warrant was executed.
Okay, any prior DWIs?
No prior DWIs, Your Honor.
License?
Eligible.
Okay. Sir, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, you will go to jail. I will revoke your bond. You understand? You're not allowed to drive unless you have a valid license and insurance in your name. If you don't have it, then likewise, no driving, and that is also a condition. We will have you sign a reset. We'll have you get with pre-trial for your bond conditions. Then after that, you'll be free to go. Okay, please, when you come back, please have a lawyer.
All right, Judge, top of 7. Garcia, Calderon.
Good morning, ma'am. Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 2026, officer in Harris County, Texas, was dispatched to a disturbance call at La Migotana. Complainant advised that defendant purchased a beer, came back inside and started a verbal confrontation with an employee and complainant. Defendant approached her and hit her in the head multiple times with a beer can. Complainant advised she felt pain and swelling on her head.
So they're at a bar.
Yes, I believe so. It's a La Migotana, Your Honor.
Let me check on that. Okay. Ms. Garcia, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You're also ordered not to have any contact with the complaining witness and not to go back to the establishment. I'm going to protect my community at all costs, Ms. Garcia. This is number 4 within 1 year. Number 4. I guess we are not getting your attention. Sometimes things may have to be more drastic. You are not allowed to be in possession of any weapons as well. If I find that you're using any kind of alcohol or illegal drugs, then I'm telling you now, this is not a revolving door. You will go to jail and I'm going to make your bond high. With number 4 already within 1 year, if I have to revoke your bond and put you in jail, I'm telling you, it's going to be a high bond. Do you understand me? You have the ability to hire a lawyer, ma'am. Do you have the ability to hire a lawyer? How are you supporting yourself now?
Family friend, and work as well, and I'm a college student as well.
How do you,
I work for a call center for refund and
okay, is this a full-time job?
It's a full-time job.
Okay, you must maintain full-time employment or be in school full-time. Deputy will give you an application. We need you to fill it out. I need to know everything about you, and then we'll take a look and see whether you qualify. Come on.
All right, Judge, page 7, Gonzalez. You're doing Gonzalez, come on up. Go ahead and slide it to the Lisa, please.
Good morning, Mr. Gonzalez. So you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 5th, 2026, officers dispatched a hit and run call in Harris County, Texas. Complainant advised that he exited Circle K on Nassau Parkway and defendant exited a private driveway traveling the same direction, causing complainant to swerve. Defendant then positioned his motor vehicle alongside complainant's and struck his vehicle on the driver's side quarter panel door. After the collision, defendant made a U-turn and traveled eastbound. Complainant followed defendant to get a license plate and defendant stopped in the parking lot, exited the motor vehicle and began yelling at complainant before driving off. The vehicle was located using block camera footage and defendant was identified by the complainant who was shown an identification ID card photo.
So she's able to identify him.
Yes, Your Honor.
Okay. Does he have a license to drive?
Yes, Your Honor, it's eligible.
Okay, Mr. Gonzalez, I'm going to find that there's probable cause to go forward with your case. You are not allowed to drive unless you have liability insurance in your name. And that is a condition of your bond. If I find that you drive without it, I will revoke your bond and put you in jail. You understand? We are going to reset your case to give you time to hire a lawyer. I will have you go to Victoria Center reset. I'm going to have you take a seat in the jury box so we get your bond conditions. Once you sign them, at that point, you'll be free to go. When you come back, please have a lawyer.
Your Honor, this case bond.
Yeah, no driving without insurance and then a license. And no contact with complaining witness.
Yes, Your Honor.
Go ahead and sign it, please. All right, Judge, next is bottom of page 8. 8 mirror.
I'm sorry, I missed the page, Vic.
Bottom of 8.
Damn, only 8? Good morning, ma'am.
Good morning.
Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On March 5th, 2026, in Harris County, Texas, officer was dispatched to a disturbance. Complainant advised defendant took his motor vehicle without permission. He called her to bring it back and she returned walking. Defendant began punching complainant in the face with a fist and scratching on his chest, causing complainant to bleed from the nose and have marks on his chest, ripping his shirt. Complainant advised he felt pain.
Got it. Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with this person. There is a protective order that has been entered now. You need, hold on. It has not been entered. I'm now going to enter in what's called a magistrate's order for emergency protection that identifies. Hey, Bernadette, on this, do you mind filing a new MOA? I think this one's wrong. Maybe that's why they didn't grant it. It's Ikmir. I think it's wrong.
What's the last name?
Ikmir.
IKEM, sorry.
Oh, no. Yeah, it's definitely wrong. Please. All right, so what I'm doing is I'm entering what's called a magistrate's order for emergency protection that identifies Mr. Hurt as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You can stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. If you violate this agreement, they can and probably will file a violation of a protective order against you. That is one of the worst misdemeanor cases you can pick up. So just no contact, no weapons. You understand, ma'am?
Yes, sir. I cannot.
Okay. Are you working at this time?
Yes, I'm working at this time.
Okay, so lawyers are based on need. You have to qualify for a court-appointed lawyer, meaning that you have to be at the federal poverty guideline. So that means you're making $15,800 a year. That's what qualifies for a court-appointed lawyer. I don't have an unlimited number. I can have you fill out an application, but if you're working and you make good money, your chances are you're probably not going to
I'm
qualify.
working,
Just don't.
okay.
I can have you fill it out. This is a sworn document. You're going to swear to it. So everything I need to know about you, and how much money you have in the bank, how much money you have coming in, are you married? Are you boyfriend? Do you have any other sources of income? What kind of car you have? And then I'll take a look to see whether you qualify. Okay, please. So he's going to give you the application. I'll have you sign a reset and then we'll have you take a seat in the jury box.
Thank you.
Please. Yes, ma'am.
All right, Judge, top of page 9, Jackson.
So can you file no contact and no weapons? And then we need a new MOA on that one.
It's the top of 9, Judge.
Got it. Good morning, Mr. Jackson. Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 2nd, 2026, officer in Harris County, Texas, conducted a traffic stop for expired registration. Defendant, the driver, had a suspended license and no valid auto insurance for the motor vehicle.
What was it stop for?
Expired registration.
Got it. All right, Mr. Jackson, I'm going to find that there's probable cause to go forward with your case. You are not allowed to drive. I don't care what you have to do in this life. If you want to drive, you must go get a license. You need insurance in your name. If you don't have either, then do not drive. I don't care what need you need, how important this is that you need to do. You don't have the proper documentation, do not drive. Do you understand? You're going to be signing a promise with me. This is an affidavit that you're promising me, swearing that you're not going to drive. Do you understand? If you go get your license, get your insurance, come back and show it, I will happily take this off. But until that point you drive, you're going to go to jail. We are going to reset your case to give you time to hire lawyers. So I will have you come up here, swear test that you're not going to drive. I'll get you to Victoria, sign a reset, and we'll get you out of here. Okay, please.
No state submission.
No, let's just get them out.
All right, Judge, bottom of 11, Brittany.
Morning, sir. So you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 11, 2025, at 11:37 a.m., officers were dispatched to an apartment in reference to a theft. Complainant advised that her ex-boyfriend stole her things. They broke up recently and defendant had moved to Louisiana. He called 2 days prior and asked if he could spend the night. He thought he might be homeless, so she let him stay the night. He took $280 and 3 pairs of shoes for approximately $723.
You stole it from her?
Yes, Your Honor, I believe so.
That's it. It's pretty close.
Yes, Your Honor, and the complainant provided officers pictures of the stolen items.
Okay. Mr. Journey, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to have any contact with this complaining witness and not to be in possession of any weapons. If you do, I will revoke your bond and put you in jail. Do not pick up any new cases. Do you understand? Okay. We will have bond conditions created for you to sign. Once you sign, at that point, you'll be free to go. When you come back, please have a lawyer. We'll have you sign a receipt and then I don't know, there's nowhere to sit, so. So no contact, no weapons. And then for her, do you mind letting her know of the conditions so that she knows? So if he tries it, then we'll know.
Yes, Your Honor.
You ready, Jen?
Oh, yeah.
Oh, top of 13, Lonzo.
Every time you miss court, all we do is revoke and then raise the bond, and you are just every single time. This is now 2. If you miss again, I will triple, quadruple, if not quintuple the bond. Do you understand? Number 1. Number 2, you are coming to court. You don't come to court in shorts. Do you understand? This is not the beach. You're not coming to play basketball with your friends. This is a court. We expect a little respect. That is not very respectful. Do you understand? If it happens again, I will put you out. Mr. Lonzo, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Officers observed defendant driving recklessly with no license plates and crashed into a ditch. Officers gave commands to stop and defendant evaded on foot. The car was registered to the complainant and complainant told officers his car had been stolen from his mother's house. Defendant was not authorized to use complainant's vehicle.
Complainant is mom?
Complainant is, it is not mother, I believe. I do not believe there's a relationship between.
Did they give commands for him to stop?
Yes, Your Honor. Officers gave commands to stop and defendant evaded on foot.
Okay. Mr. Alonso, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with the complaining witness in this case. Do you have a license to drive?
I'm looking up to see if we can get a driver's license number, Your Honor.
So, hey, This case is 2,463 days old. We set case for trial at 180 days. You will get a lawyer today, and then I'm giving you 30 days. At that point, you must come back and either accept the plea bargain or reject it, and we will set it for trial. But I'm not waiting any more time. And if you take off again, if you fail to appear again, you know what happens. Do you understand, Mr. Lonzo? Okay. Do you mind appointing him a lawyer today? And then, license?
I do not have a license. Your Honor.
Okay, you are not allowed to drive. If you drive, it's going to go really poorly for you and go sideways extremely quick. Do you understand? No, you can tell the lawyer, but I'm giving you 30 days. Do you understand? Okay, I guess we don't, you want to start moving some people, I guess, before we keep going?
Sign the conditions?
I've signed everything that's
I
signed.
put two conditions.
Okay, let's start getting,
Everybody, please sign, we'll sit right again.
Judge, were you done with Lonzo?
yeah, I mean,
All right, right this way.
sorry.
We have space over here, ready for the next two?
Yeah, how many more do we have? Lot.
Quite a few more, Judge.
Okay,
Page 13, Lozano and co-defendant judge.
Yep.
Was transferred over here from 12.
so
Coburn. I have to pay them.
I got it here. So we have two co-defendants now. Start, it's Lozano and then Coburn. Hey, I don't know how long we have Helen too, so we may want to deal with that. All right, you were Mr. Lozano, presumably, and Ms. Colburn. Both of you are charged with theft. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have each have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On March 7th, 2026, in Harris County, Texas, officers dispatched to at Walmart. Complainant, the loss prevention officer, observed via surveillance video defendants removing sales tax from merchandise and placing the tax onto merchandise to create a lesser value. Defendants also removed sales tax from a pair of sneakers and wore them around the store. Defendants were to the self-checkout and concealed the items in a shopping bag and bypassed all points of sale. Total amount stolen was $123.74.
So who is doing that?
I'm checking the dims, Your Honor, to see if we.
Who is doing what? I'm not going to just attribute both to both. I mean,
Mr. Lozano was the one wearing the sneakers, Your Honor.
okay. Is that the only thing that he did?
Or he removed the
What's the value of the sneakers?
sneakers were $34.98. I'm taking a look at the pins for, I haven't had a chance to review the pins for the code, but Your Honor,
Go for
I'm
it.
reviewing that right now. So Ms. Coburn was observed scanning at the register. And Mr. Lozano was seen removing a safe attack from a pair of sneakers where they were at the store, and then both co-defendants were seen walking out of the store bypassing all. points.
Did he at any point go to her at the register?
So co-defendant and defendant, both defendants proceed to the self-checkout register.
So they were both there?
Yes.
And then both
Yes, Your Honor. And
together as skip scanning?
yes, Your Honor. And
Got it. Okay. Well, that's what I want to know, if they're acting in concert.
Yes. Your Honor.
Because if he's just walking out of the store with the shoes, I'm gonna find no PC.
Yeah.
But if he's together, then, okay.
Stay specific with the defendant, so the defendant proceeded to the self-checkout register.
I'm going to find that there's probable cause to go forward on each of your cases. As a condition of your bond, you were ordered not to go back to Walmart for any reason whatsoever. If you do, I will revoke your bond to put you in jail. I'm gonna tell you, I'm just gonna make your bond high. I will protect my community at all costs. I don't care what you're charged with. Do you understand? Mr. Lozano, how do you support yourself these days?
Oh, like my job. I have a stable job too.
Are you working full-time? What do you do for a living?
I work at a restaurant, my DJ in the house.
Okay, do you have the ability to hire a lawyer?
You know,
Okay, Deputy, do you mind? I'm gonna give you an application to see whether you qualify for an appointed lawyer. I need to know everything about you, and then I'll take a look to see whether you qualify. How about you, ma'am? Okay, and what kind of income do you make a month? Okay. Okay. Do you mind giving her an application as well? I'll give you an application. I need to know everything about you. If you try to put any zeros, I'm going to send it right back to you. You understand? You will both sign a reset. We will have you take a seat in the jury box. Do not go to Walmart. Do not pick up any new cases. Otherwise, I will put you in jail. Do you understand? This is not a revolving door. All right. So-
Is that TJ for both?
No, I give them an application. So both of them, no going to Walmart. Any Walmart.
Judge, are you ready for the next?
Yep.
All right. Case 14, Lundy.
you're doing.
Good morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 6, 2026, in Harris County, Texas, a record driver called in regards to a driver's seat behind the wheel. The vehicle rolling through the intersection of Sabo Road and San Houston Parkway.
Whoa.
The vehicle was also driving up and over and across the Reyes Center median and through oncoming lanes of traffic.
Holy moly.
Officer observed the driver to be slumped over, appearing asleep. Officers had the driver open the door and observe the odor of marijuana from the vehicle. Officer observed the driver to have red glossy eyes and slurred speech, poor balance, and to be unsteady on his feet when exiting the vehicle. The driver was identified as defendant. Defendant denied drinking, but stated he was headed to Jack in the Box after getting munchies. Defendant admitted to taking alprazolam. Standard field sobriety tests were conducted. 0 out of 6 HGN, 8 out of 8 walking turn, 3 out of 4 one-leg stand. The LOC and modified Romberg tests were also conducted. Defendant stated he was a 4 on a scale of 1 to 10, 0 being sober. DIC was read and defendant consented to a blood draw and blood was drawn.
Any prior DWIs?
No prior DWI.
Mr. Lundy, license.
I'm running his license right now, Your Honor.
Mr. Lundy, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs, and I'm going to test you like crazy to make sure you're not using. I will test you twice a month to ensure that you're not using anything illegal. You will also ordered now not to drive any vehicle that's not equipped with an ignition interlock on it. And if I find that you drive a vehicle that doesn't have an interlock, likewise, you will go to jail. Do you understand?
I don't want with, no,
This-
uh,
No. This is not the time. You have the right to remain silent. Exercise that right. Whatever you say, don't matter how much you think it may hurt or help or what, they're going to write down every single thing you say. You need a lawyer. The lawyer will help you and you can ask the lawyer the questions that you have. But at this point, don't use alcohol. Don't use illegal drugs, unprescribed controlled medication, because I'm going to test you. If I find that you're using, including marijuana, you will go to jail. No more PR bonds. Do you understand?
Your Honor, his license is eligible.
Okay, also, you are not allowed to drive unless you have valid liability insurance in your name. If you do not have car insurance, then do not drive. Do you understand? Do you have the ability to hire a lawyer?
but court order.
That's not my question.
No.
Everybody wants a court-appointed lawyer, but we don't have resources.
Can't afford it.
How do you support yourself?
I don't support myself.
You have to eat. How do you eat? How do you get money to go eat?
Good hair, but trying to find that somebody and looking at my mother looked at me.
When is the last time that you've had a full-time job, Mr. Lundy?
That's been my full-time job. Before me.
Okay, it's now time. You don't get to get an appointed lawyer and you get to hang out at home all day doing, no. We want you to be productive. Do you understand?
Yes, sir.
And I'm going to bring you back in 2 weeks and I want to see what you have done to get a full-time job.
Yes, sir.
Do you understand? I don't know who you have in this life, but if I have to revoke your bond and make your bond 10 to 20,000, you don't have anyone to pony up that kind of money. You will be stuck like Chuck with me. Do you understand? I'm not warning you again.
Yes, sir.
Deputy, do you mind giving him an application?
Yes, sir.
So I'd like him tested twice a month randomly, please.
Judge, next is page 19, Simmons.
Hey, Vic,
Yes, sir.
any guardian interlock paperwork on Mr. Lundy, please. Yeah.
Yes.
And what's the letter?
Bottom of 19.
Wonderful. Cooking. Come on. All right, good morning, sir.
Good morning.
Sir, you're charged with burglary of a motor vehicle. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On August 29th, 2025, complainant reported that her car was ransacked and her items were taken, namely a brush, credit cards, and a pawn ticket. Prior to complainant's statement, defendant arrived on scene to retrieve items from complainant Defendant arrived on scene to retrieve items from complainant with a civil standby. Complainant received a text later from her ex-boyfriend, who is defendant's brother, asking about the tools that were pawned. Complainant stated that her ex would have never known about the pawn without seeing the ticket. Jake, the ex-boyfriend, stated that he had bond conditions, so he could not go to the residence, so he had his brother go get the items. Defendant advised that he opened complainant's door, looking for his brother's things, and admitted to taking the pawn slip, but not the other things.
What a convoluted, just,
But the defendant did admit to taking the items, or taking the pawn slip.
he goes back with a civil standby.
Yes, Your Honor. The defendant arrived on scene. Requested a civil standby to retrieve the items from complainant. Complainant received a text from her ex-boyfriend that defendant's brother asked about the tools that were pawned. And that he would never have known that information without seeing the stolen pawn ticket. And Your Honor, officer contacted the defendant's brother and the brother stated.
So it says here, the complainant received a text later in the day from an ex-boyfriend, which is his brother, asking about tools that were pawned. Complainant stated he would never have known the information without seeing the stolen pawn ticket.
The pawn ticket that was in her vehicle, and then officers reached out.
Was it theirs to begin with? Because was it his tools to begin with that she pawned?
Your Honor, we don't have that information at DIMS. I believe right now we have enough for probable cause. We know that the pawn ticket was in the vehicle and that defendant himself admitted to taking the pawn ticket.
Because they go by with a civil standby to retrieve items that were presumably there. They're not going to go to the trouble of hiring a deputy, taking the time to go down there just for, let's do this. I'm going to appoint you a lawyer today so we can try to get to the bottom of this. Victoria, do you mind appointing him a lawyer? Let me just, for now, let me have you sign a reset. I'm not going to find probable cause. We're going to do that in a minute. I'm going to give you a lawyer first so we can try to get to the bottom of it. I'm going to have you sign a reset just in case, and I'll have you take a seat in the jury box. Okay? And we'll find you someone. Come on. Something smells fishy with this. It's like, it doesn't pass the smell test, you know? Something's.
Bottom of 21, Reyes, come on up. Come to the side, please.
Good morning.
Morning.
Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 8th, 2026, in Harris County, Texas, the reporting party stated hearing a physical disturbance in a nearby apartment. Officer arrived and made contact with the complainant and observed him to have small open lacerations on the left side of his face. Complainant stated his girlfriend, defendant, got upset because he fell asleep and was supposed to be watching their child. Complainant stated they got in each other's face and started screaming, and defendant started hitting him in the face. Complainant stated he held her down to keep her from hitting him, and she started scratching him in the face. Defendant stated the lacerations on complainant's face are from scratching him to get him off her.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with this person. There's a protective order that's in place. You need to get to know it. If you do something to violate this order, they can file additional charges against you. Do you understand, ma'am? Do you have the ability to hire a lawyer?
Yes.
We will give you time. I will have you go to Victoria, sign a reset. I'm going to have you take a seat in the jury box. We will have bond conditions created for you to sign. Once you sign them, at that point, you'll be free to go, ma'am. Okay? Please.
Judge THA?
Yeah, and then state's conditions, no contact, no weapon.
Okay. All right, Judge, next is. Top of 5, Ferguson.
We're going backwards, man. What the hell?
Because I was told Alan is out of the state, and he was appointed a long time ago, since she's gone with us, so I don't know.
Yeah. Just do it. How old is this case? Let's see.
May 2025.
Hold on, Victoria, hold on. Because if it's super old, I'm gonna say no, and then we'll just put it back on Monday to see when he gets back. But if it's super old, I'm not gonna, because then we gotta wait, it's 316 days. No, keep them on. We'll put it on, figure out a day next week, and then Discovery complete?
Judge, taking a look right now, Your Honor.
Yeah. I don't have it.
We can get to you, okay.
Did you say discovery is complete?
I'm taking a look at it right now, Your Honor.
As a condition of your bond, you were ordered not to, are you chewing gum? Please. Ma'am, as a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs. Your case is 316 days old. If you take off again, I'm going to triple, if not quadruple your bond. You understand? Your lawyer's not here today, but we need to get a hold of them so that we can find out what we need to do with your case. But we set cases for trial at 180 days. Your case is now 320. So pick a day next week that you want to come back, and then we will ensure that your lawyer will be here so we can, figure out where we're going. But that's it. You understand? If you fail to appear again, I'm going to go bananas on your bond. No more PR bonds. Do you understand? All you're doing is you're giving free money to bonding companies and making it rain for bonding companies. And you have to sign a reset, you'll get with pre-operative bond conditions, then pick a day next week, whatever day you want. Whatever day she wants for next week. Yep. Yeah, no drugs, no alcohol. Right, RUAs. Yeah, thanks.
Sorry for Taurus, we said CHA.
Yeah.
All right, Judge, the next one is page 12, little.
Okay, I'm signing them up now. I'm signing them up now. She cannot give you legal advice. We just need you to sign and then okay? She cannot give you advice. No, and neither can I. So we just need you to sign and then I'll take a look to see whether you qualify, okay?
This is little,
Coming up, Mr. Little.
on page 12.
Judge, my attorney is on the way.
Who is your lawyer, sir?
Right here, Judge.
Wow. What's up? Talk about timing. Oh, wow. What's up, Norm? Yeah, absolutely. I can't let him go outside though. He's got a warrant. Yeah, for sure.
Thank you.
Hey, guys, I need to know if he has a felony warrant too. He may have a felony warrant. Little.
We had him as a line of time. So she said, find out.
Yeah, okay, yeah.
Yes,
It looks like he has a felony warrant, that's why.
okay.
So. They're talking.
Oh, okay, so we can go ahead and have a page 3, bottom 3, Chen. Chen?
Okay, Mr. Khan, you ready? Miss Helen,
Good morning, Your Honor.
good morning. Thank you so much for coming.
You're welcome.
Where did Miss? Okay, so Miss Woe, if you don't mind translating for Miss Chen.
Yes, Your Honor.
Miss Chen, you have bonded out.
陈小姐，你被保释了，
The conditions will continue.
保释的条件继续，
You will get a monitor on your ankle.
你要带那个脚踝跟踪器。
Miss Chen. Yeah. So she already has bond conditions. We just need to verify that they're correct, where she has a GPS monitor. She's not allowed to go to the Houston Galleria. There are two other stores she's not allowed to go to. It's Lululemon and which one was the other one?
From the first step, Your Honor, is at Macy's.
Right. Okay. So she's not allowed to go to Macy's or Lululemon or the Houston Galleria. We have a monitor. So Miss Woe, if you can advise her, no going to Macy's, no going to any Lululemon, no going to the Houston Galleria. If she violates these conditions, she will go back to jail yet again.
Yes, Your Honor. 陈小姐， 法官下达保释条件，就是不能够到 Houston 的 Garcia。第二个呢，不能够到任何的 Lululemon 店，也不能够到任何的 Mace 店，明白吗？因为你要带着那个脚踝跟踪器，如果发现你又违反的话，你就又被关进监狱，明白了吗？Yes or no? I understand.
If you violate conditions again, this time I will triple or quadruple the bond.
如果你又违反这些保释条件的话，那个保释金呢，可能就要升到3倍。
我知道了。
Understand?
Okay, we will have you sign your reset. You will get with pre-chop your bond conditions, and after that, you will be free to go.
那等一下呢，要在另定日期，下一次开庭日期的签名，然后又在那个保释条件上签名，那你就可以离开了。
知道60之前。
Yes or no?
Can you ask her if she's here with someone who speaks English? Miss Woe,
Yes.
can you ask Miss Chen if she's here with someone who speaks English?
陈小姐，你听到他们在讲英文吗？
啊
？What？
我听到他们在讲英语，听到了。
你听到谁在讲英语？
法官。
I understand. I heard you, the judge, speak English.
I need pretrial services to explain the conditions to her. So if she has a device,
Yes.
so is she good to go back home now? Okay, so she doesn't need to go back to pretrial services? No, okay. I think that you can let her know that we are done. We are going to reset her case. We will give her a new date, and then after that, she'll be on her way.
OK， 陈小姐，因为预审单位说你已经领到那个脚踝跟踪器，所以呢，你不用到预审单位去再办手续。现在呢，就看看他们安排下一次开庭日期，然后你就可以离开了，好不好？
好。
OK， 有呢。
Do you want to keep April 8th, Mr. Khan?
Give me 1 second.
Or we can give you a different date if you want. It's not a big deal. You tell me.
I mean, a date is fine if it's still good with the court.
Yeah. Okay, we'll keep that. We'll give her a new reset now. Okay?
Okay,
Okay?
thank you.
That's it for now, Judge.
Okay, thank you, Ms. Woe. Thank you, Mr. Khan.
Yona. Yeah, good.
Take care.
May the interpreter excuse?
Yes, ma'am. Thank you so much.
Thank you. Have a good weekend. Bye-bye.
Right. Hey, come on. Yes. Hey, so it's within 200 feet now. Are you on, Mr. Frazier?
Yes.
Right.
I spoke to them, they informed me this. Well, I watched on Friday, was being limited to 200 feet, but I noticed was that the order of this was the second, there's another violation for the 111 again for the 4-minute period. It's the same issue we had with the GPS issue.
But was this before or after we amended conditions?
So after the amended condition, Judge, but it's the same. So the way the GPS monitors work, it's not a constant 24-hour every second and every day. That's monitoring just checks in every few minutes to see what the individual is.
Right.
As long as the individual is not at anywhere within that range, it won't ding. So it's not as though the allegation states that he was there for 4 minutes. It's not as though he was there for 4 minutes, but within the 4 minutes of the check-in, he was within that 200 feet range. Judge, he mentioned that he was at a car wash. So one of you guys on the way home that he was aware that it was ding there. There were no other issues.
It's how far within the 200 feet is he?
I believe it was.
I mean, I've really tried to work with him not to have any issues and we're still having issues. I don't know what else to do. You know?
It just seems as though there were no other, after the order on the second, now being the 13th, and this violation filed on the 6th. If there are no other violations from second to now, it seems that was just a one-off radius notification, just no other matter since the amended order.
Hey, Veronica, this is Mr. Frazier. We had put a 200-foot restriction that he's not supposed to go within the complaining witness's location. How far within is he alleged to have gone? Please. Hey, Carlos.
Good morning.
How are you, friend?
Oh, that's an awful, right? What's the piece? I don't see it in my notes, but I have to message to the so real quick, the other thing that says, what is like in the it's on for 4 minutes.
You mind finding out? I mean, if is it half a foot or is he going next to the house? Those, you know, I guess give me a little bit of time because they need to figure out where.
It's an apartment complex.
Sorry.
It's an apartment complex.
Okay. I'd still like to know how close, if he's going right next to the person's house.
Right, I'm just,
I don't know. Well, we have to see. It might take a bit of time to get it done. Yeah, just give me like 5 to 10, please. All right. Hey, good morning.
I have a case number for you guys. It's gonna
Okay.
be 260-8380. And it's for Mr. Lozano,
263.
260-8380.
Okay.
And it was just a approach on the bond conditions. I emailed both of you guys a copy of his schedule.
Okay. I think we're good. Yeah.
Okay.
Yeah, we're good.
So does that mean the
Yeah.
curfew is
Yeah. Oh,
extended, waiting, or?
give me 5 minutes. Let me take a look.
Yes.
Norm, are you ready? You've been waiting. Come on. Come up, Mr. Little. It was discharged.
Yes.
What happened? What does that
There's no,
mean?
the complaining witness contacted the district attorney's office and told them she did not want a protective order, that she wanted to be back with Mr. Little. Mr. Little initially did his best to avoid her. He blocked her on all of his social media and blocked her phone number. And then she's just so clever. She went and got other people's phones and other people's social media and started sending him ambiguous messages hinting at the fact that it was her reaching out to him. And like a dumb guy, he got sucked right back in. And they got together again in love. And we got text messages from the day before his recent arrest and the day of his recent arrest. Notable features include her saying, do you want to spend the night at your house? And then he's saying, well, we could stay at your house or mine. I want to sleep in your bed. You know, and that's on March 5th. And then on March 6th, she's calling the police. And so the League City Police, this is a really interesting story, accidentally called Mr. Little. They were trying to call the DA from the felony court. because the League City Police have been trying to get this woman out of their lives. Mr. Little would be the third man that has had the judicial system used against him by this woman. There's one, her ex-husband had his case dismissed despite being on tape, telling her he would sick his dogs on her if she came around, pit bulls. There's a man in Galveston that actually went to prison behind her allegations. And then we have Mr. Little. And the police officer, when he comes out to investigate, he's always like, okay, is it the same guy? Oh, different guy? Okay. You know, everyone in League City knows her. She goes to the league, runs the League City Police Department. But her welcome is being worn out there now because the officer told Mr. Little, this woman is crazy. And then he said, I shouldn't be talking to you. I'm supposed to be trying to call the prosecutor and talk to him. So see you later. But that's what we're up against. So what we ought to do, if you want to do something fun, is let's issue a subpoena ducis tecum for her to come into court and produce her phone so that we can commence an investigation of whether she's making false reports to peace officers or attempting to obstruct justice.
There was no PC found. There's nothing for us to do.
I agree. There's not, you know, but we called, when he called me and told me what happened, I'm like, well, do you have a court date? Yeah. So I called the court and the court said, well, judge isn't here now. You need to come in on Friday. So
Yeah, sorry, I wasn't here yesterday.
No, it's okay.
But Norm, I'm not going to do anything. I mean, there's been no PC. We'll just.
I mean, if you have any jurisdiction, I'd love to get this woman under oath.
No, I can't do that. I mean, I can't subpoena her. I don't think I have the jurisdiction to do that, you know? But so he's on deferred with us. Is that the only thing? I know about the felony court, but that's not with us. I don't.
Why don't we transfer, it's a misdemeanor deferred, why don't we transfer it down here and then we can all air this thing out? Because
What do you mean transfer what?
he might do a misdemeanor deferred upstairs. She can just send that down to you and then it's a misdemeanor.
Have you heard of that?
I don't know why not. They transfer cases from court to court all the time.
No, because it still lives in that court. I mean, I can't. Yeah, I can't. I mean, on ours, certainly, I'll just reinstate. I mean, really, they found no PC, so we'll just let it go and we'll let it be as. Yeah, we'll dismiss the MHA and just continue.
Okay.
I don't know about the felony court. I
mean,
don't know if he has a
certainly
felony warrant.
judicially, if I can get the felony court to issue an order sending that down, so we have judicial economy.
I'm okay with it.
Okay.
But that's on, you know.
It's on assault, domestic violence.
Yeah, but I don't know, you know, a lot of people don't like to.
Well,
you know.
if I can keep my case, I can't keep a case in a home court upstairs. They're always sending me to one rock docket or another, you know.
Yeah, I hear that there's a lot of. Okay, so we'll reinstate. Just dismiss the motion and that's it. I mean, there was no PC.
Oh, we did.
So we'll just
Can we
everything
have-
will go back to normal.
Okay, can any, just to make sure that there's no remain, because there's two cases, and if there are any remaining no contact conditions, can those please be removed? Because I've got the text message.
Well, is that a good idea?
Yes.
If
Because
she's setting him up for failure like this, is that a good
only because
idea?
there's a no contact condition. Otherwise, they would just be another couple going back and forth. He's the one that's getting sucked into having to come to court.
I don't know. I would have to get her position first
That's
because
why
I
we
want to
get her
know.
down here and talk.
So, no. Well, what I will have them reach out to her to see if that's okay.
Oh, they'll
And
she'll
if-
tell
if-
them how terrible it is. I know.
If she's okay with it, then, you know, but I'm not going to just do it just for sake of doing it. I mean, I have to make sure that she's okay with it.
Okay.
And then if she is, then yeah.
Okay.
At this point, do not have contact with her. I don't know what it's going to take. I mean, do you need another felony warrant? You need another misdemeanor warrant? How much money have you given Norm? It's a rhetorical question. You know what I mean? Sometimes you run into something, it can cost you dearly. Some people learn once, hopefully. Some people learn. It may take 2 times, it may take 3 times. We're now on how many? Really? Mr. Little,
And I told him, I'm like, you're a good looking guy.
Talk to
You're young,
Norm.
you got a good
Really.
job, there's lots of
All right.
women in Houston.
All right, Mr. Little, good luck to you, sir. Norm, always a pleasure.
Yeah. See.
You too.
We have the interpreter for the one Spanish.
Okay, you're good, man. We're done.
Yeah.
Yeah, go. Wait, Mr. Little. That way.
Perdomo? Come on.
Carlos, is this gentleman with you?
Bottom of 15.
Are you gonna need a translator? Oh, is this a, what is? Yeah, here, I'll get it for you. All right. Sir, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 7th, 2026, officer in Harris County, Texas, was dispatched to an assault call at an apartment complex. Complainant advised that she and defendant have been in a dating relationship for 7 months and living together. Defendant was drinking heavily that day, started throwing beer bottles and breaking things in their apartment. Complainant advised that defendant told her he wanted to tie her up and force her to have sex with his cousin. Said he wanted to, quote, taste her flesh and, quote, drink her blood. Then grabbed complainant by her hair and tore a chunk of her hair out, grabbed her arm, hit her shoulder with a beer bottle, grabbed her by the neck without choking her. She stated she could breathe.
She could or could not.
She could breathe. And bit her on her right forearm, causing her to bruise and bleed. Complainant advised she felt pain.
Mr. Perdomo, I'm going to find that there's probable cause to go forward with your case. I am now ordering you as a condition of your bond not to consume alcohol or illegal drugs, and you will get a monitor on your ankle so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor, and I'm giving you a 2,000-foot radius that you're not to go anywhere near this person. If you so much as try anything, I'm going to deem you a public danger. I will revoke your bond, put you in jail, and I will make your bond extremely high. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in custody until this case is over, and then you get shipped off to immigration. Do you understand? I will protect my community at all costs. If I have to throw your butt in jail and make your bond $2 million, I will do it in a heartbeat. I don't want you to have any contact with her. I don't want you to go where she lives, anywhere where she works, breathes. You do. It will go sideways for you extremely quick. Do you understand me?
Yes.
There's a protective order that has been issued in this case, and you need to get to know it. If you violate this protective order, the state can and will file a violation of a protective order against you. Veronica. Did you have a question about conditions?
How many days do you spend on this?
Today?
And do you want to add that to the magistrates or start?
All new conditions, so it's nice and clean, no contact with the complaining witness, no going within 2,000 feet of where she lives, where she works, where she hangs out, no alcohol, no illegal drugs, tested 2 times a month for illegal drugs, GPS monitor on his other ankle so we know he's not going anywhere near her. And then we need to get that alert system as well, so that if he does go near her, then she's also made aware. There's a little alert. No weapons. And I think that's it. Anything else?
You said no evidence.
We are going to reset your case to give you time to hire a lawyer. I'm going to have you go to Victoria Center Reset. You'll go with Veronica to get your bond conditions. Mr. Perdomo, you are walking on extremely thin ice. You put hands on anyone, I'm going to put my hands all over your bond. Do you understand me?
Yes, sir.
Hey, Carlos.
Good to see you, Tish. We have an off docket bond violation that we
Yes.
received an email about, and the client obeyed the email, although he wasn't set for court, he went ahead and came on in.
Great.
Yes, sir. It's a Mr. Granados, David Granados, to have a case number.
I think we put him on the docket to deal with it. Yes.
Yes, so we did look, he didn't make it on the
Weird.
actual doc.
What is the cause number, please?
It is 259
Okay.
4231.
Oh, sorry. Thank you.
Sorry, the system's taking forever.
Yes, sir.
Come talk to me in back.
Oh, yes, sir.
Come forward.
Okay.
Deputy. Can I talk to you for a second?
Yes, sir.
Granados, come up. What is the only thing I told you not to do, Mr. Granados? Right. You have a DWI last year. Now you've got another DWI. And I order you not to drink, and now you've got two separate violations. Guess what happens now? You're going to jail. Goes with you.
You know, we were having sports setting for the 17th, and we're going to leave that day.
Yep. Yep. Okay.
Thanks, Judge.
Counsel, you ready?
I have, Judge.
Come on up.
I have a Jill. Last name is Vega, first name is Layman.
Vega.
Vega.
Oh, you got a jail plea. Okay. Did you tell them to let him know to bring him up?
I just got mine, everything's signed.
You said in jail, right?
Yes, sure.
Yeah, we need to bring, if you don't mind, please. Yeah. Hey. Let me look at the website. I get state line. Oh, are they both here? Okay, so let me do this plea and then we'll go. Yeah, let me do the plea and then we'll go.
State, how do you state?
Hey, Porsche, Porsche, I'm gonna do the plea and then we can go. Yeah, so you don't have to wait.
They're gonna leave me over by the door.
Oh, okay.
I think that's with everybody. They ain't not
No,
What I said earlier? Remember what I said earlier? Yes.
What was the last name on yours? No, you sent it to me, right?
Yes, sir.
So until what time? Like 10:30?
They would need time to get home.
Right.
So Monday through Friday, it goes at 10, but on the weekends.
I'm not letting him stay open all night. I'm not gonna let him do that.
Okay.
So,
Maybe 11, I guess, right at 11.
okay, only on the days he works.
Okay.
That's it. So it's gotta be on the schedule. We gotta have it.
Okay.
Okay?
So-
Other than that, the schedule remains.
Yes, sir.
Okay?
Thank you.
All right. And waive this, you let her know and then you can waive the signature. Okay. Counsel, you want to talk to me while we're waiting?
Yes, I know you're gonna speak to court, because I have on document PCR.
It was found no PC?
No, I'm approaching.
Oh, you want no PC? What's your cost number on yours? And then far web, if you take no. Okay, what is it?
2609.
On Gamez.
Yes. There's no context you want to look at the bond condition.
Oh, is it a new case today?
It's actually on the docket to next week, but I'm dealing with the felony in 3 hours.
Got it. Okay.
But you want to look at it. Bond conditions and a protective order on the felony case for context.
Okay, yep, we'll do.
Okay.
This is Mr. It's Mr. Vega?
Mr. Vega.
Good morning, Mr. Vega. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 198 days in jail with credit for the 67 that you've done. You need to understand something very important, that this charge will today go on your record and it will be there for the rest of your life. This comes with an affirmative finding of family violence, meaning that if you ever pick up another case like this, and it doesn't have to be where you drag down, beat the hell out of someone, you just grab an arm and squeeze enough to where it hurts, you're looking at a 3rd-degree felony, 2 to 10 in the penitentiary. Do you understand? You also give up the right to appeal, and you can never own a gun or ammunition as a result of this plea bargain agreement as well. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Is this what you want to do? How do you plead to the offense, sir? I'm going to find you guilty. I'll follow it. Good luck to you, sir. Thank you.
Thank you very much, Judge.
And make sure they're affirmative. Affirmative finding on Mr. Day. Okay. All right. Mr. Ball, you ready?
Yes.
Okay. Talk to me.
So Ms. Gamez, it's just back where in the 170, and I was appointed to that case.
Okay.
On that day, the bond conditions were amended for the correct address. It said she needed to stay 200 feet away. And she was given no threatening, harassing contact at this time, sister. The protective order was amended as well to have the correct address that was already in place. That's what I'm sorry, I said amended protective order to the right address. The protective order has no contact with this, which is different than what the no contact the bond condition has. In addition, the protective order, I think, says 500 feet away from the address, but the address is an apartment complex with a specific apartment number, not the general apartment complex. Police were called to a disturbance or a welfare check, and they found my client on the scene in the parking lot, not in the apartment. And they ran her information and spoke to the state. And this is from the office report, I'm reading the last page office report in the states. I called the ADA and spoke to Ace Miller to verify the protective order is active. The protective order stated that the suspect is not supposed to be anywhere near 1502 Enclave Parkway. That's incorrect. And she was in the parking lot. So they're saying she can't go anywhere in the apartment complex, which is incorrect. And maybe that's the reason why they arrested her versus, because there was no threatening, harassing situation documented. Now, the no contact part is not clear, and I'll take blame for that because on my end, I had the address amended. I should have had it set up where whatever the whatever the bond condition says match the bond conditions. I think that was my intent, but it didn't happen. I think I was in front of a judge. Well, anyway, so that I take blame for that, but it's not clear. And it looks like the reason for the arrest was because they're thinking she can't go to the apartment complex. That's worded in the office report. It doesn't say specific because they find her in the parking.
Your Honor, this is straight from the DIBS The officer dispatched to a welfare check at the exact location, apartment number included.
Mhm.
But she's nowhere near the apartment.
No,
So they arrived at the parking lot in front of the complainant's residence. They were dispatched to specifically the complainant's.
How far is she from the complainant's residence? Do they detail?
The officers observed the defendant outside the parking lot in front of the complainant's residence.
It's very ambiguous, you know?
The protective order requires 200 feet, looking like the amended protective order, so. I mean, we can't use the offense report, but if you look at the DIM specifically, it says he's right outside of the residence.
and
So
it says the parking lot is right outside
it
of
says
it.
the parking, yes, outside, hold on, I lost it.
And it's a she.
Gee, sorry.
Can you pinpoint, I mean, you want to look at a map maybe, and so we can kind of see,
I mean, we can contact the officer if that's going to be the point of contention.
I mean, I think it is, right? Because although it may be splitting hairs to some, she's in jail now at bond denied on the felony, so it's a big deal to her when we may be talking, feet.
And in addition, I would just like to add the context of the bond condition says no threatening, harassing, and the protective order says no contact, right? In this particular situation, in the DMs and in the office report,
But
the complaining witness, it's still her order. The complaining witness stated to the cops, I told her to come over so I can see my. Yeah, I'm just making.
she's gotta know,
Yes. Yes,
really.
I understand, Your Honor, but that's why I take blame for it being different, right? I should have cleared that up so that these type of things don't happen. Because we amended the protective order, but we amended the address, so I just didn't amend it. No, I would have seen that, contact,
Right.
On the protective.
Does it look like it's within 200 feet?
Being honest, Your Honor, from the OR.
But I mean, you can pull up on, if they can pinpoint where she was, you can see exactly on Google Maps where the apartment is relation into the,
It doesn't give a specific.
but she's in the parking lot,
And so.
right? The parking lot has a certain distance to the complaining witness's apartment. I mean, is it literally right next to it, 5 feet, or is it, 500 feet away where she was and where she was arrested? Because they're of the opinion that she can't go anywhere near it, but in the protective order, she just can't go within 200 feet. It's a big difference.
Your Honor, I have to take a look at
So
it.
they're mistaken. Right, we need some time.
All the officers.
Yeah, can you,
I'll step back, yeah.
yeah, and then Bernadette,
Today, like I said, I gotta go back as well.
sure,
I'll step back, thank you.
yeah.
The device has them at the car wash, at the part of the building. The car wash on Google Maps, 260 feet away.
Really?
They cannot tell us how
Okay,
far.
if it's 260 feet, I'm just gonna continue supervision. I don't know what happened, just,
To patrol, but they don't have the ability to tell us how many feet. He is just that it dings, that's just what the device does.
It's just within the exclusion zone, so his,
well, we said 200 feet. So not to go within 200 feet. I mean, if he's at 260 feet, then he's fine.
it's just, we can only measure from the Google Maps location, so we know that it's the street, so it's a little bit longer.
Don't worry about it. We'll continue supervision.
Excuse me.
Yeah, thanks. Okay. More.
So felony court, dissolve the protective order provision of the condition of probation. And then the prosecutor said, make sure to tell misdemeanor court so that we're consistent.
Can you just verify that? And then once they verify it, then
Yeah.
I'm okay with it.
Okay,
Yeah.
That's the numbers in the corner.
Portia, are you ready?
Oh, Alan.
You ready? Yeah.
And say everything that I'm gonna business. Flores. I need to.
I just wanted to say that quote because canceled. No
Conditions, make sure you're doing this. All conditions and these. You play sound with them, if you're on the country, you're supposed to be here, this room is awesome. And then just control your. Okay, thank you so much. As long as.
Coburn. Just the way shit about. She, I believe she was just like, because you were going to record it. Okay, you just, you were. So he's gonna talk to me, and he's gonna give me a. Yeah, thank you. Thanks. He's great. You should see our conditions.
Oh, I guess she's fine, but I don't like her, I've been on forever, she's just all the thing.
Right, yeah, yeah.
So yeah, I would need to give her a copy of them.
Okay.
Everything that wasn't in the photo. I'm sorry for that.
Last name.
Oh, Lundy? Lundy. No.
Okay.
Yeah. I was trying to. Hold on, let me make sure that was the same. He said that, you can call it part of the real quick, if you need to more. But, that's not the stuff to die, that's what I was trying to rush you to call.
Every day until you get a message that is you are selected. Then, is that's the that just.
Yeah, I had some files. What if we go to?
If you don't have any questions, This is the lead information. So when we do the testing, it's heavy and built with the color with here. We can take a picture. You can play,
Just see how those come back out.
yeah, sure.
You can say that.
Across that again. If you do have interest in putting on. Yeah. Anything that is your phone, send whether you love it. Make sure you respond to that. It's not concerned or a hand, that will be released and be on the thing. If you also like to be able to show that same thing to text, making sure they are releasing, you can also and when you truly know it is a violation. But it's something that we it is a responsibility of this if you do not receive that text message. If you have something that you try you want into the website or the computer directly in this system when you don't see that. Please really because it's the fact that it's a really interesting so if you it's not speak, so the news that we have to really want we will make next. We have a description one patient with the prescription we try for this exam, then if there is an impressive has to be so we will not allow this to be inside. We will do with the permanent which should be officer, I'm doing the windows and it's not like it is. I have access to it.
Roman?
Yeah. I think that was a lot. Here's. Wasn't on file, so yeah. I just make it about now. Basically, this guy.
Okay.
Yes.
Yeah.
Is that true? Oh, I'm sorry. I'm just looking into it. Yeah, this is this one.
You guys know where it's published. Who's here?
I'll put that out there.
It's still present, it's still, and I still think that people determine what somebody is. What we get from the hospital time. I don't really. When I said. So, I just want to show you that. Okay, you're welcome. So hello.
Oh, it's weird.
It's weed. All right. I don't know that. Huh?
Yeah, so when you burn, they got everything they need. I know that. So I went to the college, like, oh, I see it for night time. What's up with it?
Bloodshot. Personal contact. Right? He said personal contact. Right?
Yeah, that's all we need to say now.
So that's out of the, just taking it out of the information in the last couple of years.
I didn't get that.
Again. Like I said,
What's going on? I know we're doing.
The big fat steak. What smell?
I guess it wouldn't be offended.
Every month, yeah, that's, you had some very. Right number out. But they even tell me.
Is the store that I have that?
Oh. I don't
That's something I would not be more than more. Is that your? You can have a so I keep them out. Do not. And we. So far. When you get there and know what exactly. No, we'll do those there, and that's where I have a associated. The one thing, it's you're not doing anything, they didn't matter, they put a docket entry, it's like one of the ones that always do, I said at 1,000. There's a docket entry, and then you put it on docket entry, it's like that, the next day. You just didn't chase the $2 and the piece of paper to chase $2. I'm like. Do that. If there's a new docket entry, it's just all there. Easily. That's why we never.
Regarding to all your training for this. Walking and I should.
You got like all the kids around the church, kind of this. Here's the first.
He doesn't treat you all like. Just
Well, that's yeah. Brian shares. I have some feature on the phone. Sure, did that off for 2 minutes? Sorry, I'm doing that. Erica goes breathe on it. What comes then because of their Michigan. How do you watch it? 1-0. 1
I'm so sorry to keep you waiting. Are you ready? Let me help you out. I'm sorry to keep you waiting, man. Okay. Okay, tell me. Hey,
Good, I'm just here as a parent for Israel's North Carolina, but we've been waiting for,
what's the name?
we just kind of. We're getting a supervision order for.
Yay, you're done.
Yes, sir.
Thank you for coming.
Thank you.
All right. Are you ready, Kavita? Hey, Farwa, did you verify it with Norm?
Yes, we verified.
We're good? Okay, just let her know, Norm. So we're gonna take the no contact order off, but there's the no contact on Little, take it off, but still no threatening her.
No. They didn't do that either because then she's gonna say that it was threatening and harassing. They totally removed it because of her history of calling them.
But that's stuff you shouldn't do anyways.
Probably not, but I'm telling you, that's what she's gonna say. This is a very illegally astute complaint. And so the felony court considered what you're suggesting and then didn't do that because they know. And you can go ahead and confirm that too. We had that discussion.
Okay, I mean, I'll take it, but just.
Promise. It's true. Swear.
Okay, yeah. All right. Hey, I would probably counsel it's not a good idea to have any, you know what I mean?
Never like, I know.
I trust you, Norm. Don't worry about it.
I have read him write that called Read It Loud.
Great to see.
Yeah, good to see you too.
Okay, Mr. Remsen.
Yeah.
Is this all but hey, Kavita, she couldn't even stay out of trouble and she's on bond. And now Is it all but a foregone conclusion that,
Will you accept the time, sir?
is it a second?
No.
You know, Miss Remsen, yeah, of course, I would. I just, the way things are going now, are we setting her up for failure? You know what I mean? Because if history is any indication, it's up to you. I'll do whatever you want to do, but is this a slow plea?
If the state would be willing to offer it, they serve, we could definitely
What's
do that.
great state of Texas?
And you look at the flood was about 0.15.
It's up to you. But I'm going to tell you now, there is absolutely no tolerance. You violate conditions, and I don't care what it is. I don't care how minute. I will issue a warrant, and you now, with 2 cases, will have a very hard. It's up to you.
Council, what is that?
Time, sir.
Okay. Is that what you would prefer to do? Write it up.
While I'm up here, do I have a violation?
On,
Chad Mayfield, Judge.
oh, right.
Do you
What-
want the case number?
No, I got it right here. What happened with Mayfield?
It looks like he left the house at 5:19 this morning, Judge, and if I may, enough deputy pass these to you. His daughter had a cheerleading camp. that she had
I
to go
don't
to
care.
Florida, so he could get to the airport.
He's not allowed to. Where's Mr. Mayfield now?
I can be happy to do that.
It's 12 o'clock. No. We'll do,
Here's the other.
He did check in this morning, sir.
Here's the other issue. He has a work schedule and he had him on the 70 to 70, and he wanted to get it done for.
let me, that's going to take a little bit more time because I don't remember the case. We have to go through all the rigmarole. Let me get them out and then we'll talk. Okay. Where's Mr. Mayfield now?
He was here this morning, but I know that he stuck around, so I'll call you.
Is he supposed to be here today? Okay, so let's roll to Monday because it's already noon.
Well, Monday I won't be here and Tuesday, so I'll come here on Wednesday, but I think he's already set, but I'll check with Victoria. And
Well, you can always zoom in
Yeah.
from the Bahamas. I don't care where you
I'll be at a pediatric.
are. Yeah, whatever. Monday or Tuesday, whatever you want. All right. Mr. Ball.
Following back up about the PT issue, I'll let the state talk first. I know there's some notes, then I'll.
So was she within 200 feet or no?
Yes, Judge, so I can speak to Judge, I just got here, Judge.
That's okay. Well, Bernadette went to call the officer.
Bernadette, Judge, the officer, she, so officer. So Bernadette, the officer said to Bernadette that the defendant was within 200 feet, Judge. So that's what the officer says. And looking at the body cam, Judge, this is a kind of condensed apartment, Judge. The parking lot is in the center of the complex, Judge, and then it's surrounded by the.
Damn, so damned if you do, damned if you, because you're gonna be within 200 feet then, regardless?
That's based off what the body cam shows, Judge. That's
What do you think?
correct.
So two things. When you first asked, you went to ask about the 200 feet. She went and she spoke to him. She spoke to the officer. Officer went in his name. She asked a lot of different questions. And again, I wasn't on speakerphone, but I was in the room and she was asking me questions, right? I want to be privy to the conversation. I wish it had been on speaker. It wasn't, right? But he didn't definitively say it's within 200 feet because he couldn't tell her what floor it was, right? Because I was in the room in the back room with her friend when she was talking to her. She said, if it's 200 feet, it wasn't a yes or no thing. I don't know 100% what was said. But then as we were walking out, I said, what did he say? And she didn't speak about the 200 feet. She said, the officer said he was inside that she was inside the apartment, which was something she was trying to inquire about on something else. So I said, okay, he was inside the apartment. Who told you that? Officer Wynn said, but Officer Wynn didn't see it. No, Officer Wynn didn't see it, but the complainant told him that. I said, okay, complainant told him that. Let's go see if there's body cameras. So I pulled up his body camera. It's there. I'm viewing it. This is the body camera. Now. It's like 4 minutes. At no point does CW say she went into the apartment. She specifically.
Well, I don't care about that. I mean, right.
200 feet. They don't go into her apartment. They don't know where her apartment is. If anything, her apartment's back here, and that is more than 200 feet. So they don't go back there to even find out. So that's not true. If they can't tell you it's within 200 feet because they didn't go to the apartment to check out. I've watched the whole video. I watched the 4-minute video when they're talking to her.
But did she at one point go near or within the 200 feet?
No, that's what I'm trying to explain, Your Honor. The officer doesn't know that. That's why they didn't put in the office report based off the body camera. At the body camera, she's outside in the parking lot talking to her. Client's already arrested, and they talk to her in the parking lot.
So who is that right there?
That's the CW. That's the cop talking to CW trying to understand what happened. What happened here is they got arrested. She got arrested because they thought it wasn't allowed to be an apartment complex address versus a specific apartment. There was a mistake made between talking to the A and
I understand that. I understand. That's why I'm with you on that.
Yeah, they don't clarify that, and so for him to say one, she was in an apartment is just not.
Well, I'm not holding that.
I know you weren't.
I don't care.
Didn't say it, but the officer doesn't know where her apartment is to tell you if he was in 200 feet. If he is trying to say that, which is probably why he wasn't sure when he was telling Bernadette the answer, because she asked him, was he within 200 feet? What's your best guess? You have to ask him 3 times. And he doesn't know because she doesn't know where her apartment. They don't know where her apartment is. And it's clear on the video.
If I may, so just to start off, Judge, the defense points out one body cam that's 4 minutes long. Judge, there are multiple body cams. One of them is 1 hour and 20 minutes long.
Well, I don't care.
Yeah.
But what I care
is, Judge,
can he pinpoint exactly where she is in the parking lot? And then we use Google Maps to
speak. Bernadette told me that the officer told her, yes, Judge, defense implying that my division chief just, why, Judge?
No, I didn't say a word.
No, I don't think he's implying. No.
Okay, implied, Judge, but I think that's, we're past PC.
No, we're not past Judge. The cop didn't go into the house. I mean, it wasn't a 4-minute video, it's an hour video.
But I think that,
area.
I have to imagine
Yeah.
that he probably knows, he's got the apartment number, he knows where the apartment is, so he can make a observation where she is, where he arrests her at is within 200 feet.
Your Honor, the body cam comes on, her policy and interaction occurs. You see my client already arrested. He talks to CW in the parking lot. He doesn't go to CW's apartment. He doesn't know where CW's apartment is.
I understand.
The most he does is this, and he's trying to guess me. That's 200 feet. That's at least 75 feet till you get to the apartments, right? He doesn't know which apartment she is for him to say that, which is why they wrote the DIMS, which is their sworn statement, and an office report the way they offer. Now the state's trying to get more information to get around it, but they don't have that information because they didn't do the work to do it. This is an hour-long video, and there's different plots. It's not a 4-minute video. It's 4 minutes and 15 seconds when they start talking to her. That's what I was saying. This is an hour-long video. Officer Wynn is the person she called because that's what the office report and did the sworn statement, right? Is she swearing to something that's true or not? He doesn't go into the apartment complex to find that out. What it is they arrested her based off a mistake. They arrested her thinking she couldn't come to the address. And they said that in the DIM, and they said that in the office report. They didn't do the work.
The information is listed wrong though,
As far as the
about what her conditions are. As far as the VPO is concerned, the information's wrong.
As far as what's on the VPO, Judge, or
As
what's
far
on
as
the
what
information?
conditions she has, right? The condition for her is she's not to go within 200 feet of where the complaining witness lives.
Yes, Judge.
The information says something totally different. So they're using incorrect information to make a charge.
Judge, my understanding of what the protective order says is that it's within the address and the apartment's number.
Well, hold on. What's the last name? Let me look at this.
Yeah, man.
Right. All right, so the protective order says committing family violence, acting further than 4207-2, communicating a threat. Going to or near the residence of a family member of the household or protected individual, specifically within 200 feet of the residence and the Enclave Parkway.
So Judge, if I also may add to that, Judge, Bernadette did speak with the complainant. She said, and I'm gonna read verbatim, she said she drives up right by her apartment because she lives right off the street. And then she parks in the handicap room right there. So she also lives by the street, Judge. So even for the defendant to get there, he'd have to go through the street, Judge. And I would argue that.
Yeah, that doesn't make sense. Whatever you just said right there doesn't make sense. Because apartments have fences, right?
We-
You can't pull up. And you can see the apartment.
But we don't know that for sure.
Yeah.
You know, like, I have to be certain that when we're finding probable cause, we're not doing it based on a hunch, on an assumption. You know, here, the charge is wrong because it says here, unlawfully and with knowledge of issuance of a magistrate order for protection, violate said order by intentionally, knowingly going to or near a place specifically described in the order to with the residence or the protected individual.
Yes, Judge, but because I believe it is citing the attached protective order that is listed as an exhibit in the information, the state would argue it's specific enough to be referring to that order, Judge.
I don't know. Let me do this. I mean, this is gonna take a lot longer and the line is building up. Let me get them out.
Okay.
This is gonna take longer.
I gotta go back up to 178, it's having DVR, and so I was trying to have.
Go and come back.
But they're gonna.
What?
Stronger argument.
I know, but this is gonna take longer than I anticipated. I don't want to make people wait. They've been waiting a long time. Ready? Sorry to keep you waiting. Come on up.
Our job, right? I have Mr. Simmons in the box.
Okay.
Wanted to hear-
You got it pointed to Simmons?
I did.
Okay. Yeah, I pointed because I was kind of,
Yeah, I did see that. Well, I don't know where you want to start with it. I don't know if I should start making my argument.
is there a PC or no?
I don't think so.
Why?
I believe one. First, I think that I would argue that there was effective consent from the owner of the vehicle. They get property out of it. That's why they called for the civil standby to be there. So I would argue that she understood that they were going to go into the car and get that property. And
But I'm not gonna assume that. I can't assume that.
Your Honor, that's not stated.
Right. We don't know that for sure.
well, somebody had to call for the civil officer to be there.
Because the other guy had, I guess, a protective order that didn't allow him to
And
go
so-
get his own property.
Right, and so he sent his brother, which is. And to that end, I would also argue that he didn't have the intent to commit any felony or any theft here. He was going to retrieve property that he had permission to retrieve that did not belong to him.
Does that give you the right to go into someone else's car, though? And essentially break into it?
Well, if he opened the door, like I said, I think in this case, it's not just entering, it is entering with a specific intent to commit a felony or theft. And I don't think that he had that intent at the time. When he goes in, when he has an officer with him, and he was going to retrieve property as directed to him.
Because he didn't just take the pawn ticket. There were other things as well.
Allegedly.
Stolen items and the
Allegedly.
car was.
I think she said a hairbrush and some.
Yes, hairbrush, credit cards, and then.
Oh, the credit cards, right? I mean,
Sure,
do
but.
you know whose name the credit cards are in? Because that would be big.
The 3 credit cards, Your Honor, it doesn't specify.
Man, they couldn't tell us who the credit cards are. I mean, is it really hard to write a damn good offense report?
I still believe.
I mean, are we
there's-
asking for too much?
I
What the
still
hell?
believe there's a probable cause, Your Honor. She reported stolen items from the vehicle.
She did report those stolen?
She did report them.
Yeah,
She told them a name, she called it, they were missing. I don't know if they verified that they were even missing or whose credit cards they were.
The items were taken from.
Right. Come up, Mr. Simmons. So the only thing I'm gonna find it, but I'm gonna just say no contact. That's it. Mr. Simmons, I'm gonna find that there's sufficient probable cause to go forward with your case as a condition of your bond. You are not to have any contact with this person or go where she lives or works or her car. Do you understand?
Yes, sir.
If you violate this condition, if you pick up a new case, I'm going to revoke this bond. I will put you in jail. No more PR bonds. This is not a revolving door. You understand? We have given you a lawyer. It is your responsibility to stay in touch with her. If she tells me she can't get a hold of you, then likewise, I will revoke your bond. We'll just have him sign conditions and you guys are good to go.
All right, thank you,
All right,
Judge.
good luck, Mr. Simmons. So can you file those, please?
Yes, no contact.
No contact, no going to where she lives, no going to the car, no weapons. I need her. Because she's got a husband. She didn't have much of it.
This is on the last.
Okay, hi, please. Yes.
Two clients on the, docket today. The first one is Rivera Acosta, BDR.
Okay,
She's in the jury box.
Oh, okay.
You're alleging a curfew violation by a few minutes, Your Honor. I do have a letter written by my client apologizing and explaining the reason behind the curfew violation.
okay, just let her know. I'm gonna continue supervision. Just don't let it happen again. Let her know if she does. This is not,
Thank you.
okay.
We are also requesting that curfew get extended. The reason she was in violation is that she was trying to work her AA.
Okay, sorry.
Her AA sponsor was helping her find work at the time. He also knows a lot of the facilities invited her to work on site. On their way back, they were caught in traffic and that's why her custody was violated by a few minutes. She is seeking full-time
Okay.
employment.
Great. If she gets a job, then we'll talk, but I'm not gonna give her leeway and then in the hopes that shit does happen and then she goes out and she's, no. If you do, then let me know. We'll talk, but I'm not gonna take her word for it that she's, no. So, but I will pending if she does.
Yes, Your Honor. And the second client is Lonzo.
Okay,
He had one conditions already, Your Honor. One of them is no driving. He does have to drive to Austin.
he doesn't have a license.
Sorry?
He ain't got a license. Lisa he ain't got a license. You ever watch Weird Science?
Sorry? No.
Don't worry about it. You ever see that movie? Lisa he ain't got a license. He ain't got a license, right?
I don't have a license.
He doesn't have a license. He can't drive. If he has a license and insurance, I'm happy to do it, but he doesn't have a license. Yeah.
Your Honor, can I just see the
Hey, and then on that one, it's 4,000 days, so 30 days, he gotta be back. So, Lonzo,
4,000 days?
it's 4,000 days old.
Yes, yes.
Yeah, so I said 30 days.
To make a
Yeah,
decision. Yes,
yeah,
Your Honor.
okay.
I have spoken with Vega. Yeah, and I'm talking with the county prosecutor as well. Talking with the county prosecutor as well.
Okay, yeah, I'm not gonna hold it. I'm not gonna wait. No. It's 4,000, no.
Yes,
Yeah,
understood.
okay.
Thank you. Can I keep
Have
the
fun.
conversation on the monitor? No contact with the complainant, no weapons.
Yeah, no alcohol, no dope. It's a PCS?
It's a evade.
Oh, it's an evading.
Yes.
Yeah, just no contact, no weapons, I think.
And then-
There's no alcohol or any, or
No
dope?
allegations.
Yeah, okay, you're good. Just a no contact. Yeah, okay. Hi. Yes, ma'am.
Right, I'm approaching on Miguel Garcia, you sent him to get tested earlier this morning.
Okay,
And I spoke to the pre-trial services officer here and she said that he came out presumptively positive for THC. I spoke to my client.
this case is 6 months old and he's testing positive. No, sir. Mr. Garcia, come up.
Judge, you didn't come back.
So he left pre-trial services at 10:55.
Okay, so it's all right. I'll just revoke it. Just, well, I'm gonna keep you on for now. I don't know, maybe he'll come back and then we'll talk. I don't know.
Yes, sir.
So I guess don't call us, we'll call you. Okay,
The bond approval?
for now.
Okay, thank you.
Yeah, okay. Have fun.
Oh, he's in the Garcia.
No.
We got about 15 Garcias, man.
I was telling you.
Judge, I'm approaching Mr. Feliciano Roman. He has bond violations. We have an attorney, do we have an interpreter here to speak? To speak, yeah. But I will convey to the court that his urine test that you ordered earlier this morning came out negative.
But he's still using elsewhere. A 0.163. Mr. Roman, come up.
Judge. The difficulty with that is if you look at the, it says 0.03, and then the second test is a 0.16. I would suggest to the court that that brings up the possibility we may have a malfunctioning breath device. Because you've got a wide divergence in two tests that were taken less than 15 minutes apart. So if he was in the absorption phase, he could not have absorbed, what, 4 drinks in 15 minutes.
Could you
Also,
conceivably take a buttload of shots?
yeah, but not in 15 minutes. You couldn't absorb 4 drinks in 15 minutes. And if he was in the removal phase, it should be going the other direction. So a wide divergence raises the specter, at least, that
Regardless, Owen, he still has alcohol on board. I agree with you that there's something wonky with the blows. Mr. Roman, how much do you want to go to jail? How much do you want to go to jail? ¿Tú quieres ir a la cárcel? You're begging. You will now get a monitor on your ankle, so I know that you're not consuming alcohol. And if you ever have a hot blow again, into jail you go. And I don't give a rat's behind what your excuse is. It's absolutely no tolerance going here forth. Is discovery complete on this case?
I'm taking a look right now, Your Honor. We still need to get in touch with the complainant regarding any restitution. We just got confirmation of defendant's insurance. We still need to get in touch with the complainant. We just got confirmation of defendant's insurance.
Please get on it. Okay, it's getting old. I'm giving you 3 weeks. I don't know if you guys are interested in PTI. If you are, then it's got to be done 3 weeks. In 3 weeks, you will be back here. You must either accept the plea bargain agreement of the state, or I will set your case for trial. Mr. Roman, any more violations, into jail you go. Do you understand me?
I don't understand very well.
If you have another positive for alcohol, you will go to jail.
Quietly.
Do you understand?
Your Honor, I didn't understand. Let me understand.
Si tú tienes un positivo por alcohol, tú vas a ir a la cárcel. ¿Me entiendes, Méndez? Mírame. Mírame. Si tú tienes un positivo por alcohol de nuevo, vas a ir a la cárcel. ¿Entiendes? ¿Qué te dije? ¿Por qué? Exactamente. Y vas a tener algo en tu tobillo para que yo sé. 24 horas al día. Okay.
Did you want to switch him to a scram or how to the point?
No, switching to scram plate, scram first. Okay. All right, Owen.
Thank you.
See you soon, friend.
All right.
You said 3 weeks to do what?
3 weeks, plea or trial.
They go and marry.
It's a lot of drama, man. A lot of drama, you know?
Good afternoon, Your Honor.
Hi, what's up?
I'll say hey.
What's up? You got something with us today?
No, I was leaving out from another client,
Hmm.
another courtroom.
Thank God it's Friday, huh?
Oh,
My
it's
goodness.
definitely the happier hour.
Hey, shh.
Well, you know, when
You might-
this,
I don't want you to
roller coaster
inspire.
Weather, it's supposed to be spring break, so
Did you say roller coaster weather?
it's roller coaster.
Did you see what happened yesterday on the news? I think it was like was it in Ohio? These people go on a roller coaster and there's a 13 or 14 or 15-year-old girl behind, and it's a 78-mile-an-hour roller coaster and the thing goes up. So they literally, the two people in front are holding her in as they're going in this roller coaster, and the roller coaster going 70 miles an hour. They're literally holding her. She's yelling at the top of her lungs. Can you imagine that? And the roller coaster, they had 20 malfunctioning seatbelts earlier in the day.
And they still keep it going.
You know, just,
I mean, it's-
I mean,
I was just getting ready to
and
say-
my son loves these roller coasters. I'm like, here, look. Woo. I mean, just
There was 5 minutes, the timing is
Okay.
You hear me?
Man.
Anything mechanical. I think maybe like 3 to 5 minutes.
I mean, you know, but it's bad because a lot of times we feel like we have the perfect personal injury case. It's usually the client who's like, I can't make it to the doctor. I can't get it. And you're like, bro, we got the bag right here.
It's always the $1 case.
Always the $1 million, the case that I could send my retire office. With the client thing.
yeah, I know. It's great.
Well, Judge, you gotta get rid of this docket. It is
I know, we're
Friday,
trying, I know.
Great seeing you, Your Honor.
Great scene. Hey, you ready? What you got?
Judge, I've got a Brady or Christina Brady. It's in the docket for Layman, she's in custody.
Do I need to bring her out?
I'd like to hear PC. I don't know if you bring out PC.
No, let's just do PC real quick. We got a lot of stuff that we still need to do.
On August 4th, 2025, police officer was dispatched to a house located at 1130 Banner Drive within Harris County, Texas, in regard to a family. Complainant is defendant's elderly aunt who is 75 years old. Complainant stated that she has been allowing defendant to stay at her home for the past 1.5 months. Complainant stated that defendant got upset after complainant tried to talk to defendant about cutting back household expenses. Defendant yelled at complainant and approached complainant while holding a large glass cup. Defendant then threw the glass cup at complainant, narrowly missing complainant. The officer described the glass cup as one that was made out of thick glass and had some weight to it. Said glass cup was about 5 inches in length, and the officer said glass cup is a deadly weapon capable of causing death and serious bodily injury.
I mean, death is a stretch. I mean, but so did she get cut? What happened?
No,
She narrowly missing.
She missed.
But complainant is 75 years old.
And of
Oh,
course, it's,
does that play?
I think it does play a factor, but I say first, it says the person walked up and threw it there and just hurt. I can understand why they're trying
Let's
to.
hold on. Let's read the statute because let me pull it. Hold.
It's a person commits an offense if he recklessly engages in conduct that places another in imminent danger of serious bodily injury. That person commits an offense if he knowingly discharges a firearm. That's not ours.
No, I think it's under A. C says recklessness and danger are presumed if the actor knowingly pointed a firearm. No, that doesn't.
So if the glass cup did hit the complainant, judge, it would be an act. That's all. Because we give a beer bottle at sauce.
And I understand the beer bottle and all of these things, you know, possibly, maybe.
But it didn't though.
It didn't hit her.
Right, that's why it's not upstairs.
I don't-
Because if it did.
Would it not be an attempt?
No, because if it did, no, because we don't normally, charge attempts like that, Judge. I work intake. A lot, and we normally go either the assault route or the dead conduct route, Judge.
So I guess the question is, does the complainant have to suffer a harm for this charge to stick? You know what I mean? Because I think that, are you alluding to the fact that she didn't get injured as a result of that?
I'm even alluding to that fact. I'm alluding to the fact, you know, first of all, it has to at least be reckless, right? Your mens rea. First of
If
all,
you're throwing a cup at someone, it's a glass and she's 75 years old.
Claiming you threw the cup, but I mean, honestly, right, if I walked up on you, if I wanted to hit you, I just hit you with the cup, especially at 75, you're not getting out the way. I don't know how agile he's 75.
Oh, I'm not gonna, I mean, we're not gonna.
She just throws a cup and, you know, out of anger or whatever, she's not, you know, they say narrowly misdemeanor, and these are just facts, you know, and I'm sure that's for a jury, but do I think it's truly deadly conduct? Or I believe this person believed that, hey, this cup was
That's not, it's, but it says here, imminent serious bodily injury. If you throw a cup at someone, it's glass. Like it's the eggshell plaintiff, you know?
I absolutely under that, but even, I think eggshell plaintiff typically goes to civil court, so I don't.
I know, but I'm saying she's 75 years old, man. You throw a glass cup that's thick as hell at her cranium, what's gonna happen?
We don't know how thick this glass cup is.
Well, you said it was thick.
It was described as a thick glass cup, Your Honor. A thick glass.
Police
That's what you
officer
use.
describes.
Yeah.
I think there's enough. Sorry. Yeah.
I'm serious. You already want to try this case.
We're not that far.
I think I am.
Yeah.
I think I
Yeah, come on, bring it. Let's go.
Page 9 and 10, the Jackson's first initial day.
Are all these people late?
Yes, Judge.
Okay. Sir, you were charged with 2 counts of failure to stop and give information. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 1st, 2026, officer in Harris County, Texas, was dispatched to an accident. Complainant advised she heard a boom and realized one of her motor vehicles was partially inside her living room.
Inside her living room?
Yes, Your Honor.
Holy moly.
She ran outside and saw multiple motor vehicles in her driveway had been damaged. The complainant observed defendant.
Oh, hold on a second. Did she give an attitude?
Yes, Judge.
Come up here. Come up here. You've been giving attitude all day, man. Take a seat in the jury box.
You don't get taking feet down to the restroom. So you don't just tell them, come go to the restroom, that's funny. So where I go.
You can take her back.
Oh, no, to the restroom. Okay, I believe you.
No drama today. No drama. Please.
Complainant ran outside and saw multiple motor vehicles in her driveway had been damaged. Complainant observed defendant exit into motor vehicle and flee the scene on foot without providing any information.
So after he bangs into the house, he takes off?
Yes, Your Honor.
Okay.
And then there's a second complainant who stated he heard a boom, observed defendant exit and flee the scene on foot in his motor vehicle, which was a primary motor vehicle struck by defendant. Complainant 2 observed defendant enter a nearby residence and waited for officers. Officers made contact with the defendant who stated he was leaving to go to the store when his glasses fell, and while reaching, his foot hit the gas, causing him to collide, and he left the scene because he was scared.
Okay. Does he have a license to drive?
Yes, Your Honor, it's helpful.
Okay. Mr. Jackson, I'm ordering you not to drive at all. If I find that you do, I will revoke your bond on both cases and I'm going to put you in jail. No more PR bonds. This is not a revolving door. Do you understand? How old are you, sir? Do you have the ability to hire a lawyer? Okay, we will give you time. I'm gonna have you go to Victoria Center Reset. I'm gonna have you take your seat in the jury box till we get your bond conditions. Once you sign them, you'll be free to go. Understand these are serious bond conditions and I expect you to comply. If you get out there and just think you're gonna do what you do, it's just not gonna go well for you. Comply with it. Do you understand? Okay, come on.
Your Honor, this
Yeah, no driving.
No driving.
Yeah. Are you ready? THA and then states conditions, no driving.
Okay. The next one, Judge, is, page 23.
Hey. What is her last name?
Ferguson.
What's she got to do? Sign bond conditions? Okay, let's get her up here so we can get her out. Miss Ferguson, come on up.
Ferguson. Judge, I don't think they were filed yet.
Oh, hey, they're with Veronica. It's no drugs, no alcohol, random testing. And this is the one where we're waiting for next week or what? So just Veronica, can you take care of her so we can get her out, please? We're gonna have you sign bond conditions and then we're gonna see you next week. If you act up like this again next week, it's not gonna go well for you. There's a certain decorum in the courtroom. When we start acting up, it just doesn't go well. Please. No, you have to sign for your conditions. We're gonna give you a reset and then you go.
Judge, I'm sorry. She already asked conditions from the magistrate. It's the random drug testing, no drugs on the firearms. Did you want to keep those?
Yeah, just keep those. Yeah.
Wait for the next one.
I wanted to just approach again on Brady for bond.
Okay.
I wanted to speak to her first. I had just saw the glass cups. I came up, guns hot, guns blazing. But Ms. Brady did let me know that she does have another place to stay with her friend. She is a longtime Harris County resident. Well, her whole life she went to Cypress High. She lived in Channelview. She says she's not working at the moment, but she does an odd job. She goes and helps at some car washes, does some other work.
So I want you to verify that she has an actual place to stay. Like, we're not going to take her word for it. Like, you need to know where she is. And then if I give her another PR bond, she's going to get an ankle monitor. She's been gone for like 300 something. Let me see. Yeah, for 225 days. So.
Oh, this is
Yeah, she's been gone for 220 something days. So. Dick, do you want to call up the next person?
Yes, Judge.
Come on.
Give me 2 minutes. Page 23, Wilson.
So as far as confirmation, you just
Read,
actual
so,
address.
so she should give you a phone number, call them and ask them, hey, can she really stay with you? You got a place to stay for her? Because I'm not gonna take her word for it and I don't want her out on the street.
Absolutely.
Wilson, you say?
Yes, Judge.
Good morning, Mr. Wilson. Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 5th, 2026, in Harris County, Texas, officer observed a vehicle with no license plate enter into a gas station. A traffic stop was conducted, and defendant exited the vehicle and was advised of the reason for the traffic stop. Defendant stated he did not have his driver's license on his person, but showed a picture of a temporary driver's license. Officer ran defendant's identifying information, and his driver's license returned as not eligible.
Mr. Wilson, you're on felony probation. You're supposed to be living like you have a halo above your head. You've now picked up a new case. You are not allowed to drive. That is a bond condition of yours. I don't care what you got to do in this life. You want to drive, go get a license, get insurance. But until that point, if I find that you do, I'm going to put you in jail and I'm going to make your bond high. Do you understand? You will be signing an affidavit. This is a promise that you're going to make to me today that you're not going to drive. I don't care that you need groceries. I don't care that you got to go to school. I don't care that you got to work. If you don't have the proper licensing, don't do it. You must get approved from us first if you get it. Do you understand? Do you have the ability to hire lawyers, sir? Do you have the ability? How are you supporting yourself these days? When is the last time you've had a job? In and out and in and out and in and out. In 2 short years, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, and now 16 in a matter of 2 to 2.5 years. What do we need to do to protect our Mr.
I am going to count them.
What do you think? What are appropriate conditions to place on a 16th case within 2.5 years?
The driving, Your Honor, the drugs, no alcohol. Just to make sure he's monitored. Driving while license.
Take your seat for me in the jury box.
Judge, yes, stated in the meeting here, at this time, the state is requesting a GPS to be placed on the defendant with,
What time of day or night was this? Was this in the middle of the night?
It happened at. Yeah, it was 11:30.
Yeah, I think that you're probably.
Thank you. Thank you, Judge.
Okay. Farwell, Kavita, you ready? Do we have one more? Coming up, ma'am. Ms. Remsen, you were charged with driving while intoxicated. You're also charged with terroristic threat. The agreement that you have worked out is they're going to dismiss the terroristic threat in exchange for your plea. You need to understand that this DWI will go on your record. It will be there for the rest of your life. Every time you get pulled over, officers want to know who they're dealing with. They're going to see this. If you smell like alcohol or dope, what's going to happen? You need to be on notice for the rest of your life. Every time you get pulled over, they're going to look you up. You smell like alcohol or dope, and they see a prior DWI. You understand? If I were you, even if you have a sip of alcohol, don't get into a car. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, it will go on your record. You can never take it off. You understand? From now on, what we're doing, it's a minimum of 30 days in jail from now on. There are no more proverbial slaps on the wrist. Do you understand? How do you plead to the office? Guilty or not guilty? I'm going to find you guilty, send it to this agreement. I'm going to suspend your license for the minimum, which is 90 days. Do not drive until you get a license, and good luck. Okay. Yeah. Okay. Thanks. Please sit there. Oh, we're Twinkies. That's so sweet. Have a great weekend. Council, you ready? No? Close.
Yes.
Did you find a place?
I did.
And call verify?
I called it verified. It's her uncle. His name is Mr. Earl.
Okay.
Mr. Earl said immediately she could stay and he would come.
So we'll do a GPS prior to leaving. Let her know it's never going to happen again. No, it's a deadly, so no contact with the complaining witness, no weapons, and then, we'll give you a couple settings. It's an old case, so it won't hold open forever, but okay. So just let Veronica know, or can we reinstate on? You know what? So Veronica, on Miss Brady, a GPS prior to release, no weapons, no contact with the complaining witness, and then stay in contact with the lawyer. No waived appearances, so she's got to be here at the next setting. It's old. Okay, counsel. Yes, ma'am.
Good afternoon, Judge.
Hi.
I'm here on Mr. Alexander.
You've been waiting ever so patiently. Alexander. Okay.
So, he was hospitalized, from the day that, he was supposed to, the day before that he was supposed to, I think, do a blood test for Lyme condition, all the way until the 11th. I think he got discharged yesterday.
Is he here now?
He is here. He
Okay.
has already taken it. He went down, taking that. But he's been hospitalized, so.
Is he under like health or mental for
No,
hospitalization?
he had like a physical.
Okay,
thing.
got it. Okay. So even if you test positive, I'm not going to do anything yet. I usually give them about 50 days, but let them know that this is not forever. If that's, that's not good. Did we order no alcohol, no drugs? So here's what I'll do. I'll put a scram on him now. Any further violations, he'll stay with me. Let him know.
This is his, and there may have been some confusion when his bond conditions were signed about that.
Did I put that condition on, or did the magistrate put the bond condition on?
When I had gotten a point, I think.
If it was me,
already-
if it was me, it's usually for a reason, like usually alcohol is a factor in the case.
I understand, Judge.
And I put
By
it
the
on.
time that you did,
Is it alcohol a factor in the criminal mission?
I'm taking a look right now, Your Honor.
This was given, it looks like it was by you because he was instructed by Roxanne.
Yeah.
Taking a look at it right now, Your Honor.
Come up, Mr. Alexander.
There's no allegations in this case
Hmm?
regarding any drug and regarding any alcohol, Your Honor.
Any, anything with any illegal substances then? I guess read me the DIMS real quick.
Yes, Your Honor. On February 6, 2026, in Harris County, Texas, officer was dispatched to a criminal district call. Complainant advised that he was inside his motel room. When out of nowhere, the suspect banged on the door/window aggressively, bending the bottom of the door to where it was unable to be locked. The cost to fix the door was $650.
Okay, I'll take it off.
Thank you, Jen.
Yeah, okay.
Your Honor, I would, given his history.
I know, but you know, it's not, if it was something that were a factor here, then I would agree with you. But when you over condition, it doesn't do any good, you know, really. We have enough drama as it is. We don't need any more. Just don't pick up any new cases. You understand? Okay, man, take care. We'll address, just let her know.
Thank
We'll
you.
take off the no drugs, no alcohol and testing. Okay?
Thank you, Your Honor.
They're waiting around for this last one.
I need her to refill because she's married. Mr. Ball. Yeah, so, I mean.
So I don't know what more to state in that, when they said they didn't have an apartment, most recently, I think for that is.
It does.
Okay. The other end is that the apartment wasn't.
He may not have been looking at the amended protective order, but the
Correct.
amended protective order does have the apartment number on it.
It's just,
That's correct.
Okay, Judge, I'm gonna be the only person handling this case. Apparently, there's been an indication that I have lied to the defense attorney.
No, there's not. There's not.
I am
No.
not gonna let any other prosecutor touch this. If this.
But there's
this
not.
To be a very common thing that is thrown out, so.
It's not,
I
it's
am
not.
prepared.
By people, what do you mean by?
No,
Yes.
please, it's not a big
Yes.
deal. I think that there's a lot of confusion because we don't know exactly where she is. And as you can guess, when reports aren't written in such a way where we can pinpoint exactly where someone is in relation to the apartment, tensions can run high. So
But
is she within 200 feet?
I believe that she is based on Google Maps. If you look at any handicap parking spot in the apartment complex and go to the furthest point to the middle of the street, it is less than 200 feet. So if she is at any handicap parking spots, if the apartment is as far as the street beyond all of the apartments, she is still within 200. In the body camera, she says that the defendant drives on the outside of the street, which is closest to her apartment, that would be within 200 feet. She pulls into the apartment parking lot and parks in a parking space, which would still be within 200.
So I think the argument they just made is, so for example, old apartment I used to live in off West Belford and Buffalo Speedway. You drive past West Belford, you turn into the apartment, and then you have the ability to depart 200 feet away. Is that the argument they just made, that she drove by? With
According to the body
Even,
camera.
even where she is in the apartment, where she pulls in the handicap space, she's still within the
And
200.
my argument is that she's not, because they don't know where the address, they don't know where her apartment is. They know the apartment number, but they didn't go to the apartment. They don't know which apartment it is. Here's the thing, right? Again, I keep saying this, I think it's important. On the DIMS, they didn't say this. On the office report, they didn't say this. We're trying to look outside of that. She spoke to the officer.
But they can though.
Well, what I'm saying, and which is why I've been doing my follow-up, which is why we got to the body camera. The officer told her that somebody complained with us, told her that she was in the apartment. I went this room and go to the body camera. I went to the body camera. That's not stated in the conversation on the front end at the 4-minute part or later on at the 40-minute part. I spoke to CW. CW made it clear. She did not go into the apartment.
None of that matters though.
But no, what I'm saying is, because that was a contention that the state made. So, and I'm also saying, we don't have the information here to say where the apartment is. They had it where she was arrested for being at the address. And to your point, like you've been saying, that's incorrect. She can be at that address because the order says 313.
I agree with you, but she's still within the 200 feet. She's
Yeah.
in the handicap parking spot is within 200 feet.
Your Honor, the state doesn't know that. The cops don't know that. And the cops didn't arrest her based off that information. The cops arrested her based off the idea that she was at the address, which is incorrect.
Well,
That's my probable cause.
The DIMS also indicates the protected person was inside the apartment, and she said that she had, okay, I'm sorry, I read that wrong. My mistake. On that one.
So the DIM says that she was in the apartment.
No, it says that the protected person was inside the apartment.
Right.
So that's what I had misread.
So, Your Honor, the time they arrested her based off false information. That's what I was saying. They arrested her.
Oh.
Careful.
I have been a victim of that, and I did not go down that gracefully.
So Did they incorrectly arrest her? And can you, I guess, cure that, so to speak? I mean, does
Yes,
it?
I have a request in to be put in a grand jury on Monday, so it's not indicted. I think we have sufficient information. On the.
You get indicted?
Well, if no probable cause is found.
Oh, I see.
Yeah,
Right.
that's my only remedy.
So let them indict it, Your Honor, and give us a chance to put in a package to show it wasn't within 200 feet, because the cops don't even know what apartment is, because they didn't go inside the apartment. They didn't do the measuring. They're doing these guessing. This is also the same cop who said, yes, she went into the apartment. This is the same cop telling you 200 feet as the cop who told her she went into the apartment. That's the same person. She didn't go to the apartment, claiming when said it, but we're gonna believe this cop saying it was within 200 feet, and we're gonna believe Google.
But the only thing that really matters is she within 200 feet?
I don't believe she is, and I don't believe there's information, enough probable cause information to figure that out. And I don't believe the cops knew that at the time.
But they have it on Google Maps that it is.
Yeah, we know how Google works, but is this?
I gave it the most generous in the favor of the defendant's measurement that I could possibly measure. And if you cut across the entire apartment complex from the middle of the handicap parking spot to the middle of the street, it is 126 feet. If her apartment is the furthest one, it's less than that.
And it also changes if she's on the 3rd floor. There's so many things the way of getting to people. And all I'm saying is, they didn't know none of this information at the time. They arrested her because she couldn't get into the house. I mean, the whole apartment complex was off limits, and that wasn't the case. That's why they wouldn't be here arguing this if that was the case. If the cops had took a little bit more steps, they were trying to find a reason to take her in jail. To be totally honest with you, this happened in this case. They're trying to find a reason to take her in jail because they believe she was intoxicated. They shouldn't get to do their reality, but they didn't. They said, "Oh, we're gonna arrest for BPO and get rid of the situation." They didn't think they were helping, right? Because the sister called because she's said she was, had welfare issues about the kids. So that's why they arrested her. They didn't arrest her. And I don't know why they didn't do that, but they did not do it. They can't do that now. They arrested her incorrectly.
I mean, do you have anything to support the position that if they made the arrest based on maybe incorrect information and they can cure it later and it's okay? Because I don't know. I mean, they're arresting based on the fact that they think at the time that she's just not supposed to be at the location at all, when in fact there is a protective order and that says you can't be within 200 feet, but she is within.
So the closest I have to it is Miami, North Carolina. That's a Supreme Court case where the officers incorrectly, arrested somebody for a traffic violation that didn't exist. And because it was actually not a legal thing in which the person they put over was doing, but then they found drugs later, and then the court said they justified it. Unfortunately, for the law enforcement in Texas, we have 3823. So you can't have an incorrect arrest and then try to cure it later. That's the whole point of having 3823. Your instruction saying it codifies the, as you know, Your Honor, exclusionary enforcement. That's the purpose of it. That's why we don't have no discovery in Texas, because of 3823. So in essence, I think that's what it sounds like. No discovery argument. Okay, we arrested her and then we found out later. The only reason you found out later because you arrested her. The only reason the information that they're gathering, which you consider evidence of discovery that they have now, because they arrested her. Unfortunately for the state, they arrested her incorrectly. So all this information she's gathering, her talking to the officer, her talking to other people, that's all information they're gathering because they arrested her. And it was an incorrect arrest. Because they arrested her based off the assumption she couldn't go into the apartment. And she can be in an apartment. So they should just did their work and said, hey, they could have took 2 more steps. What apartment are you in? Let me just gauge it. But they didn't do none of that. They didn't leave the apartment. They thought they had enough for the BPO and missing crucial information. And any information they found out after that, they can't use, Your Honor. That's what this 3823 is codified.
So, Judge, in response to defense's argument, that would be an issue for a motion to suppress, Judge. Just even though defense does cite 30 and 23, there's a huge carve out for officers acting in
Good faith,
Judge.
right? I think that you're right. That
it was listed in the order, right? They had the images. They had it in good faith. It would say the apartment complex. They read the wrong order, right? It was listed. So you're saying officers around here reading the wrong protective order and people are getting arrested, right? There has to be some pushback to that.
she's still within 200 feet, and it's her job when you're on bond, you have to know what you can and can't do. You can't just try to skirt it. You know, this is her 1, 2, 3, 4, 5, 6, 7, 8th assault or VPO. You know, you know, if you're on bond and you've been on bond since, you know how things work. You can't just, well, I guess it's okay if I do, you.
Why do we know she was within 200 feet? That's what I'm saying. We don't.
She is given a copy of the protective order. She knows what she can and can't do.
My question is, how do we know she was in 200 feet of the apartment? That's my question. We don't know that. You do not know. Why are we just taking that as solid that that was the case when that's the same officer that said she said he was in a.
How do you know that she's within 200 feet?
I pulled it up on a Google map.
How do you know that? How do you know that?
I pulled up.
I understand that you pulled it up on the map, but how do you know that she's right there?
Based on the information in the DIM, she's in a handicap parking spot. I looked at every.
Is there a
handicap parking
video
spot.
there with her in a handicap
You
spot?
can see the handicap the spot that she's in, and you can see where the apartments are. You cannot tell exactly which apartment is the complainant's apartment.
And who puts her in the car in the handicap spot? Is that not sufficient?
Your Honor, just want to ask a question because I can see where this is going. If I.
I mean, I think that
If I go
there's
out to the
no-
address and get a measuring tape and then show you it wasn't 200 feet, would that be more information? Because it's short of that, because it's the whole.
Yes.
idea of looking at the information.
I mean,
I think that's what I have to do, because it's coming down to 200
Sure, but
feet.
that's an issue beyond.
No, I don't think it is, because they're saying, it can be an issue beyond probable cause, because they're saying she was within 200.
I agree with you. If you come back here and you have some video or some picture that shows me that handicap spot where she is parked at, it's more than 200 feet, then I'd find no probable cause.
Thank you. Thank you.
Okay,
Thank
thanks.
you for carrying this whole thing off document.
Of course, not a big deal. I appreciate the tenacity.
Thank you.
Of course.
Just two things, for Brady, can you, that you can virtually, I cannot bond week, sorry, I can't believe it.
So do another PR bond.
Okay.
Yeah.
And then I have to, bond conditions.
If y'all plan on getting this case indicted, you said, you know, you know.
Did you want?
No, I'm saying,
I didn't hear. Yeah, no, it's a deadly conduct, so no contact, no weapons, no going to where she lives, the complaining witness, no going to where she works, and then the GPS because of the prior bond, I guess, the flight.
It's not a question of how I don't have this.
Let me see. I don't, hey, do we have a call?
No, yeah.
Oh, I see it. Okay, so that's an assault. No drugs, no alcohol, no going to La Michoacana, no weapons, random testing. And then no contact with a complaining witness or going where they live or work. Okay, do you have another arraignment for real? Holy moly, come on.
Never ending. Page 24, Lyric.
Around that way, please. All right. Good morning, Ms. Wyrick. Sir, you are charged with criminal trespass. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On March 1st, 2026, in Harris County, Texas, officers were dispatched to a criminal trespass at a Velvet Taco. Complainant, the general manager of Velvet Taco, stated defendant had previously been criminally trespassed from the location.
You say Velvet Taco?
Yes, Your Honor.
Okay.
On this date, complainant instructed defendant to leave multiple times, but defendant refused to comply. Defendant did not make any purchases while inside the establishment and locked himself inside the restroom for approximately 2 hours. Defendant was inside the restaurant asking the customer for money. Officers observed defendant inside the restaurant and asked defendant and told defendant he was being detained, but he refused to comply and stated he was not going to provide his hands. Officers attempted to detain defendant, but he became physically resistant by swinging his arms and nearly striking officers. Defendants resisting resulted in a physical struggle that moved into a different room. Officers placed defendant off the ground and defendant continued restricting. Officers were able to gain control and place defendant into handcuffs.
I didn't notice that he also has 2 cases. You were also charged with resisting arrest. On that one, you're facing a year in jail and or a $4,000 fine. Okay, Mr. Wyrick, I'm going to find that there's sufficient probable cause to go forward on both of your cases. As a condition of your bond, you're ordered not to go back to the Velvet Taco. You understand? If you go back, I will revoke your bond. I will put you in jail. No more PR bonds. Do you understand? This is not a revolving door. I'm not asking much from you. I want my city safe. I'm doing everything in my power to protect it. You understand? All right. It's kind of late now. Do we have any lawyers around?
I'm gonna hide. I have one.
You don't want a court-appointed lawyer?
No, I'm just good.
Are you sure? Okay, if you have a problem and you want a court-appointed lawyer, just let me know. And I'm happy to give you one. We'll give you 30 days. Just, sir, don't go back. I'm not asking much, okay? We're gonna have bond conditions created for you to sign. We'll have you sign a reset. We'll have you sign bond conditions. Once you do that, at that point, you'll be free to go. Okay, sir.
Your Honor, is it any Velvet Taco or just specific?
Just that one. It's not like, yeah.
Judge, did you want us to go back to bottom of 23?
Can I help you, ma'am?
I'm just a law student. I was just observing.
Oh, okay. Welcome.
Thank you. Conditions for Simmons in your queue.
All right, Mr. Simmons, come on up. There, we're gonna have you sign your conditions. We'll get you out of here. Okay, Veronica, are you ready on Mr. Wilson? All right, come up, Mr. Wilson. Right here. You will now get a GPS monitor on your ankle and you will get a curfew of 9 p.m. to 6 a.m. And you must get a job. J-O-B. 2 weeks. You're to come back here and show me what you have done to get a job. When people have too much time on their hands, they become self-destructive. As you now working on number 16 within 2 years. If I test you and you test dirty for alcohol or dope, I'm going to go bananas on your bond. Do you understand me? No alcohol, no illegal drugs, no driving, no weapons. And if you're out at night, so help me. Do you understand? 2 weeks. I'm going to give you a lawyer today. Well, it's now late. It's now 1:15. I'm going to give you a lawyer when you come back, but 2 weeks. Do you understand?
Jackson?
Weekly.
Mr. Wilson, on your next book,
Can you send him home with let's send him home with an application.
Oh. Sign your
Oh, make sure Veronica, on everything, waive all the fees on everyone. Okay. Victoria, we need him to also sign the no driving affidavit before he leaves as well.
We're gonna have him come back up to it.
Yeah, I might as well.
He's gonna sign a no driving affidavit.
Yes, I have it.
Hey,
Lawrence.
and then we have that one guy back there. Okay, we'll let him out here momentarily, and I think we're almost done. You wanna go through the list? Yeah.
Top of the two. Go to the
5,001?
Yeah,
Nah.
bottom of the grid.
Oh, he didn't show up. So 5,001.
Bottom of 10, except for Raymond goes over here, first time.
2501,
Same thing for top of 11.
same thing.
Yeah,
That many, huh?
Bottom
Man,
of 14, same thing.
how many agreements did we do today too? What the hell? 2501.
All right, page 15, same defendant. Two bonds listed on the.
5,002 on both.
Let me know when you're ready.
All right.
What time you have any inmates to know? What time you have any inmates to know?
Veronica, you done with Brady? Oh, no. Okay, no worries.
Hey, we can bring the other guy out and admonish him with the scram. What was his name? It's Carlos's dude. Carlos's guy. Carlos Rodriguez, the lawyer. It was crap, it was off docket. That's it. Good job. You're the best.
Okay, yes, and you did that to put it back on the 17th.
You get to scram today.
And I just pushed some new conditions in your future.
Great. Thank you for the help today, by the way.
Yeah, even the next, every round.
Hey,
Veronica, I think we're close. We're done. We're close to be done. Thank you so much for the help. Don't say that. Careful what you wish for, as they say. All right, home slice, who's next?
20, bottle 20 set for Raymond, here.
2501.
Top of is 21, so what you do with that?
5001. No show.
Top of 22, it's a BBR that's been MIA.
Say it again.
Top of 22, it's a BBR that's been MIA.
Okay, 10,000 and let me see how many times homeboys then. This is that one. Remember he came with a mom or something. Remember that?
Did you like it?
Oh, well, yeah, for me, yeah.
I want to play
Okay. 10,002. Yo.
We have a lawsuit.
Yes.
Student from South Texas who involved the.
Yes, yeah, let me, we're close to being done. That's the last one. All right, let me say bye. Okay, we're done.